Pardon. Pardon to mention, my lord. Writ appeal number 313 of 2020, my lord. Can it be listed next week, my lord? Give it.
Yes, madam, this case contempt proceeding has been initiated. Contempt proceeding has been initiated against the officer matter. The writ of petition is for fresh admission. May be listed next week.
I don't mention, my lord. I petition for a recall of the order, my lord. I petition to recall the order, my lord. On 14th August, let me drop the contempt petition. In fact, the order has not been complied with. For I have filed to recall. Pardon to mention, my lord. WPC 7823 of 17. Order of a tribunal has been set. And the matter has specifically page to 18th August. But it has not been restricted. Under criminal operating distress for a bail only. On
No, sir. Item number 55. The matter pertains to implementation of Second National Judicial Pay Commission, Your Lordship. As per the direction of the Honorable Apex Court on 19/5/2023 as well as 4/1/2024, the revised scale has not been revised yet, Your Lordship. It is in the list, Your Lordship.
Yes. And at item 75, I have filed a miscase, my lord. There is, we have selected as booth strain manager, and while we are going to join in the same post, they have issued a notification for fresh selection. I filed a miscase only. That may be taken up in orders, my lord. 14925 of 2025.
75 item. 77.
74.
This.
Mine.
Let's say item number 73. Today was fixed. I'm very injured. I'm injured, not able to speak in. Kindly fix it.
You are the petitioner.
No, sir. I am the opposite OP number 1.
73 item.
Yes.
What is your name?
Satyan Kumar.
You have got power in this case.
Escape. Escape. Something.
We are marking it to see them.
I'm telling a moment. I am challenging the order of DRAT. I am the petitioner. I am the owner of the land. The opposite partner 4 tenant which applied for the connection of electricity. Despite of protection and the petition filed for the DRAT is not allowed. On basis of challenging this order, my lord.
Tribunal appeal court fresh admission, my lord.
Quickly list item number 1.
Let me please, your lords. This review application, my lord, I have sought for review of order under Annexure 5, by which your lordships have disposed of the writ application at the stage of admission, thereby confirming the order of the Central Administrative Tribunal with a direction to release all the pensionary benefits of the petitioner. Well, my humble submission is, well, the petitioner was not having 10 years of qualifying service. I challenge the order, more particularly if your lordship will turn to the impugn the order of the tribunal. My lord, at page 106, paragraph 5.
But it may be he has retired from service since 2012.
My lord,
and he has got the benefit. You are challenging the order.
My lord,
Union of India. Why are you?
My lord, the one thing is, my lord,
persons,
your lordship may kindly.
After so many years of service, from 1980, you are serving for till 2012,
and he has retired, and you are just to give some benefit. That's how you are challenging. You filed the writ petition. Writ petition was dismissed. Now you have come up with a review.
My lord, that will open the floodgate. The whole difficulty, if your lordship will.
It is decided in individual cases. No question of floodgate.
My lord, similarly,
We have considered the factual aspect of that case and stated that there is no infirmity in the order of.
My lord, your lordship,
Union of India and
your lordship.
You are in the review also, you are arguing the same thing.
No, my lord, one aspect. Paragraph 5 was not taken into consideration.
Man, senior citizen, and you are after him. You are Union of India.
Your lordship, kindly consider one aspect, my lord. Para 5 of the impugned order of the tribunal, my lord, that has not been taken into consideration.
Taken in the review.
Lordship, kindly.
Satisfied with
Lordship, kindly allow me to place that paragraph 5. Your lordship has not recorded any finding in respect of paragraph 5.
You have other options.
My lord,
Item 2.
my lord, he was not having 5 years of service as held by the tribunal. He was just having 1 year of service
Yes, item number.
for that period, my
All
lord.
right.
Make clear. The petitioner challenge here is the order of the Reliance Central, which is tribunal under Annexure 6 at page 40, by which the Reliance Tribunal has directed to give appointment to the OP number 1 on compassionate appointment, under compassionate appointment scheme. And in fact, the father of the OP number 1, while undergoing treatment at hospital of the company, was transferred, shifted to, was referred to SC Medical College, Cuttack, where he on 1/11/2010, we took admission on 7.
Come to paragraph number 5.
Of the writ petition.
No, the impugned order.
Yes. At page 46. The tribunal in its order dated 13/1/2003 in TA number 1 of 2020 at para 14, taking into account the treatment letter issued by SCB Annexure A by 2, wherein specifically mentioned the deceased employee was suffering from hollow viscous perforation, and after investigation is seen that he was suffering from cardiac problem PSVT and kidney disease for which the emergency surgery could not be done, and died on 7/11 due to PSVT cardiac arrest. In the said paragraph 14 of the order dated 13/1/23 also stated as to how cardiac arrest is also another term for heart attack. In para 15 of the said order, this tribunal had directed the respondent to consider the case. Said order, this tribunal directed the respondent to consider the case of the applicant for grant of compassionate appointment. Nowhere in the said order, this tribunal had directed the respondent to constitute a committee. When a medical college like SCB Medical College, Cuttack, one of the foremost medical college in India, gave the cause of death to be cardiac arrest, it is surprising that doctors from company hospital of respondents sit on that report to analyze it, and then go on to find a conclusion that death was not due to heart attack. This tribunal had clearly directed TA number 1 2020 to not to go into the hyper-technicalities of medical terminology for rejecting the case of the applicant, but the respondent still did the same. The further contention of the respondent that 13 years have passed. Then paragraph 6. Normally, this court, in the case of the compassionate appointment, this tribunal remits back the matter for consideration. But in view of the discussion made above, as an exception, this tribunal, while passing the impugned order dated 9/23 being bad in law, illegal, arbitrary, and non-application of mine, direct the respondent to grant appointment to the applicant under compassionate appointment scheme.
So, the order earlier passed in the TA, that was very clear that direction was issued to the respondent to consider the case of.
Yes, we have considered
that. No, you could have challenged the order. Now what you have done, what the tribunal says, that it was, though the SCB Medical College granted the certificate that it was a case of cardiac arrest.
Yes.
You constituted a committee and took a decision that it was not a heart attack.
The
It
tribunal,
was not heart attack.
yes, but what
These technicalities you have gone into and
no, the
rejected.
tribunal had never prohibited to go into technicality. The tribunal had never prohibited to constitute a committee.
Tribunal has stated very clearly, come to that order of the tribunal in the earlier.
Yes, ma'am. Yes, ma'am.
PA number 1, where is
Yes.
the next that order?
Yes, ma'am.
Annexes 3.
Page 34 or something.
Come to that.
10 lines from the top. Even though the death of the deceased employee had not been categorically mentioned from 10 lines from the top at page 34. Of the deceased employee had not been categorically mentioned as dying from heart attack.
No, come to the last 4 lines, 5 lines. Therefore, in our opinion.
In our opinion, the deceased employee suffering and undergoing treatment both for heart and kidney, and his death resulted from that it satisfies the eligibility condition as per the scheme, and the respondent should not have gone into hyper-technicalities of terminology while dealing with the case of the applicant. The citation relied upon the respondent are not applicable to the peculiar facts and circumstances of the case where this tribunal finds the respondent have acted illegally and without due application of mind for non-consideration of the case of the applicant for long period of time. Accordingly, in view of the above discussion, we directed to the respondent to consider the case of the applicant for grant of compassionate appointment and pass a speaking and reason order to be communicated to the applicant within 1 month.
Yes.
In terms of this order, we considered his case. While considering, we constituted medical committee of 3 doctors of the company.
No. You see, that in that way you override that that whatever the findings given by these professors.
No, in fact, Lordship will find the tribunal relied upon the.
If you constitute a committee only to not to give appointment, then this will happen.
No, in fact, there is no conflict between the medical report of the committee under Annexure 5, which is constituted subsequent to the order, and the order of the SC Medical College under Annexure 5.
Why don't you trust the medical report of SC Medical College? You should have trusted that.
Who did not distrust this man? In fact, there is no conflict. There is no conflict. There is distinction between heart stroke and cardiac arrest.
There is only one post forward.
Huh?
Only one person you can give. What is the big deal for a company like you?
Your employees like.
But in fact, Your Lordship kindly appreciate there is a lot of difference between heart. The scheme is so.
Steel Authority of India and fighting against this one man. He died compassionate appointment to his.
He died due to cardiac arrest, not due to heart stroke, man. That is the distinction.
This petition has been filed by the petitioners for setting aside the order dated 1/5/2025 passed by the 11th Central Administrative Tribunal Cutoff Bench in OA number 154 of 2023. The opposite party, number 1, Ashok Kumar Giri, filed the original application with following prayers, quote the prayer portion that has been mentioned in seeking for following reliefs for the page number 2,
41.
Page number 41. It appears that earlier the opposite party, number 1, approached the London Central Administrative Tribunal Cutoff Bench in TA number 1 of 2020 with a prayer for a direction to the opposite parties to appoint him under the rehabilitation scheme. Stop. It is the case of the opposite party, number 1, that his father was working in raw material division in Bola ore mines of the petitioners organization, and he died in the year 2010 due to CSVT, cardiac arrest. the opposite party number one submitted, mother of the opposite party number one submitted an application dated 5/1/2011 to appoint the opposite party number one under the habitation scheme dated 26/8/2010. No response was received from the petitioners, for which another application was filed on 28/2/2011, enclosing all the documents, and also reminder was sent on 15/4/2013. Since no response was received from the petitioners, the TA number 1 of 2020 was filed.
No, writ petition was filed here, that was
That was
transferred.
transferred.
The writ petition was filed before this court by OGC number 15028 of 2013, which was transferred to the Central Administrative Tribunal, Cuttack Bench, and accordingly, TA number 1 of 2020 was registered. On issuance of notice, the petitioners filed their counter affidavit, wherein it is stated that the father of the opposite party number one died on 7/11/2010, and at the relevant period circular dated 26/8/2010 was invoked for providing employment on compassionate ground in certain category of cases of death arising out of specific diseases for the employees of RMD. RMD টা পর্যন্ত raw material division. But unfortunately, the father of the opposite party number one was suffering from hollow viscous perforation, bracket SBP, and the death was on account of such disease which was not included in the category of ailments mentioned in the scheme, and accordingly it was paid for dismissal of the original application. It seems that the opposite party number one filed the rejoinder affidavit, including certain documents, including the copy of the legal heir certificate and in the rejoinder stand was taken that the father of the opposite party number one was treated in SCV Medical College Hospital, Cuttack, and also the department of the petitioners opined that the father of the petitioner had died suffering from cardiac problem and kidney diseases. An additional rejoinder affidavit was also filed by the petitioners, reiterating that the father of the opposite party number one death does not come under the scheme, for which the opposite party number 1 is not eligible to get appointment under the rehabilitation scheme. However, it is stated that PF amounting to rupees 7,45,115 and gratuity amounting to rupees 3,17,700 was paid to the nominee of the father of the opposite party number 1, and the family of the opposite party number 1 did not opt for benefit under the Employees Family Benefit Scheme, wherein the last salary up to the actual date of superannuation would have been paid to them. The Learning Tribunal took into account the stand taken by the petitioners that the cause of death of the deceased employee being not one mentioned in the list, that is failure of kidney, heart stroke or cancer, comma, the opposite party number 1 is not eligible for grant of compassionate appointment. After considering the pleadings of both the parties and hearing the land counsel, the Learning Tribunal has been pleased to hold as follows. Quote paragraph number 14 and 15. Stop. It appears that after the said order was passed by the London Central Administrative Tribunal on 13/1/2023 in TA number 1 of 2020, comma, the petitioners constituted a committee of experts comprising 3 doctors of company's hospital at Volani, and they gave a report dated 8/2/2023 that the deceased employee did not die due to any of the disease such as failure of kidney, heart stroke or cancer. Taking into account the committee's report, the petitioners came to hold that since the deceased employee did not die due to any of the disease stipulated in the scheme for compassionate appointment, comma, the claim of the opposite party number 1 was rejected. The Learning Tribunal, the opposite party number 1 challenged the rejection order dated 9/2/2023 inter alia with prayer as mentioned in the first paragraph of this order. Stop. The Learning Tribunal, after hearing the land counsel for both the parties and stand taken by the petitioners, came to hold as follows. Quote paragraph number 5 and 6. that is page number 46 and 47 of Annexure 6. Mr. H.M. Dhal, Learned Counsel appearing for the petitioner, submitted that since as per the order dated 13/1/2023, the Learning Tribunal directed the petitioners to consider the case of the opposite party number 1 for grant of compassionate appointment and pass a speaking and reasoned order. And there was no prohibition for constituting a committee, comma. The petitioners constituted a committee, and the committee examined the material documents, came to hold as follows. Committee's report number
Page 39.
37
to last.
Annexure 5.
37 row.
Last as per.
As per the observation of the said committee, said quote kar do, page 37 should have sorry chief 38 na, he died on the same day due to
It is further observed.
it is further observed.
Issue.
ऊपर जाओ।
It is your observation made company.
हाँ एकदम पूरा लग गया 38 रो company percent.
Which is contrary to the SCB report.
The Learning Tribunal has been pleased to hold that when a premier hospital of the state like SCB Medical College doctors have given the cause of death of the father of the opposite party number 1 to the cardiac arrest, it was not proper on the part of the petitioner's company to constitute a team of doctors and to give a report denying to negate the report of the SCB Medical College just to just not to grant the relief sought for by the opposite party number 1
Taken out of the scheme.
and took him out of the scheme. After going through the findings of the Learning Tribunal, we find that the tribunal has taken into account the earlier order passed by it on dated 13/1/2023 in TA number 1 of 2020, the report of the SCB Medical College authorities, the contrary report furnished by the doctors of the company of the petitioners, and rightly came to hold that the order dated 9/2023 passed by the petitioners is illegal, arbitrary, and suffers from non-application of mind. The direction of the Learning Tribunal to the petitioners to give appointment to the opposite party number 1 under compassionate appointment scheme dated 26/8/2010 suffers from no illegality or perversity. Accordingly, the writ petition being devoid of merits stands dismissed. Yes, next.
Item 3.
May I please also. Here the petitioner with the proprietor's business Miller challenging the sufficient action initiated by the opposite party Bank Miller
Now, besides that, the outstanding is the petition is 2 crores 56 lakhs Miller. As for my instruction, Miller, the petitioner and the guarantors are ready to repay the loan.
Won't pay the bank.
Miller,
Who stops you?
Yes, Miller. The only difficulty is they have already instituted before the district magistrate to take the physical possession of the
Obviously.
property. Not only that I will abide by any Miller the conditions. I will
Why are you wasting time? Go and pay there in the bank. Everything will be stopped.
The outstanding is 2 crores from or Miller.
Then if you want to make it by way of installment, option is lies to approach the alternative remedy.
In fact, Miller, every time I orally appeared before I physically appeared before the bank and orally requested them to.
You withdraw the writ petition with the liberty to go and approach the bank.
Yes, Miller.
That is the best way.
The writ petition has been filed by the petitioner, Messrs. Bharat Trading Company, represented through its proprietor Srimati Kausalya Devi Modi, which is at about 79 years, for a direction to the opposite parties Kotak Mahindra Bank to consider the prayer of the petitioner for one-time settlement. It appears that the bank has already issued notice under section 13(4) of the Surface Eye Act, and thereafter the bank has approached the collector and district magistrate cutter under section 14 of the Surface Eye Act, and accordingly bank in case number 53 of 2025 has been instituted and notice has been issued to the petitioner, and the case was posted to 16/7/2025, which would be evident from annexure 5. In view of the settled position of law as decided by the Honorable Supreme Court in the case of so and so, since alternative efficacious remedy is available with the petitioners, we are not inclined to interfere with the impugned order, impugned notice. However, it is open to the petitioner to approach the opposite party's bank with a prayer for one-time settlement, and in the event such an approach is made, the opposite parties shall consider the prayer of the petitioner in accordance with law. It is made clear that we have not expressed any opinion on the merits of the writ petition. Yes, next.
Item 4.
File that copy of the order and dates of the. So in this writ petition, Miller, I am not challenging any order.
Kindly see
Two
the
issues raised, Miller, here.
Kindly see the prayer.
My son,
Prayer is to
Page 10.
was the order dated 3/1/24 and 7/2/2024 by the CGM cutter opposite party number 1.
You are agreed by these two orders. Why do you say that you have not challenged?
because I have
They
said
want
that
implementation of those orders passed by the DCP as well as the CJ. This can't turn into an executing court of those orders.
What is the terms of that order?
no, Miller, page
They
10
filed
shall
a,
not be implemented, not the first I'm asking prayer.
No, 13/2/2024, the order has been already passed in your favor.
My lord.
So the So DCP Cutter and IAC Swanso and the secured officers were asked to take necessary action.
No. But it is not getting implemented.
That-
I'm not after the
The
crossing.
last copy is at page 36, which was, the date was posted
30?
36. Notice, that is the notice from the DCP to IAC.
3/6/2025.
17/4/2025, Your Lordship.
74.
Page 36, Annexure 8.
Yeah.
The date was fixed to 21/4. Thereafter,
Nothing happened. That is what the precisely
They
the
have to-
issue is here.
they have to approach the judicial magistrate, Your Lordship, for that.
Mhm.
But
They
the-
have
if I
approached
can
the
sub-
appropriate court. This court cannot be turned into executing court.
No, it is not. I'm not seeking an execution from this honorable court, my lord. It is not getting implemented in view of section 14. Section
Let us
14
see that
speaks
I have
about,
to say after.
if the lordship may kindly see the act.
Just a minute.
My-
Come to that section 14.
My lord.
There is a time limit for 60 days. Your Lordship.
If I will place it, section 14.
Which are the relevant provisions?
I'll only place the relevant provisions, section 14, the first paragraph. Where the possession of the secured asset is required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred by the secured creditor under the provisions of the act, the secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing the CMM or the DM within whose jurisdiction any such secured asset or other documents relating thereto may be situated or found, to take possession thereof, and the CMM, or as the case may be the DM, shall on such request being made to him, take possession of such assets and documents relating thereto, and forward such assets and documents to the secured creditor. Thereafter, the amendment came, the 9-point affidavit was there. Then a lordship may kindly see the amended
Thereafter?
provision.
What came?
Thereafter this amendment, my lord, provided that
Provide.
9-point affidavit has to
Yes.
be there. Then another amendment came, my lord, 1A, if a lordship may kindly see, section 14, 1A. The district magistrate or the CMM may authorize any officer subordinate to him to take possession of such assets and documents relating thereto, and to forward such assets and documents to the secured creditor. 2. For the purpose of securing compliance with the provisions of subsection 1, the CMM or the DM may take or cause to be taken such steps and use or cause to be used such force as may, in his opinion, be necessary. But both the provisions put together,
The obligation,
the
on,
obligation on the magistrate to take possession. So that was interpreted even by the Honorable Supreme Court as well as the Honorable High Court of the Allahabad. They categorically say that it is the obligation on the magistrate to take possession. The second issue I have raised in this writ petition, which is subset of the first issue, is
There one just decision that Supreme Court.
my. Paragraph 16, if you lordship may kindly.
Yes.
Place it. The statutory obligation enjoined upon the CMM or DM is to immediately move into action after receipt of the written application of section 14(1) of the SOFACI Act from the secured creditor for that purpose. As soon as such an application is received, the CMM or DM is expected to pass an order after verification of compliance of all formalities by the secured creditor referred to in the proviso in section 14(1) of the SOFACI Act, and after being satisfied in that regard, to take possession of the secured asset and documents relating thereto, and to forward the same to the secured creditor at the earliest opportunity.
as observed and held by this court in NKGSB Corporation Bank versus Sudhir Chakraborty, the aforesaid act is a ministerial act. It cannot break the time is of essence, and this is the spirit of the special enactment. So the obligation is on the learned magistrate. Well, the second issue is here, if that is so, well, under which provisions, I'm asking this question to myself, the police is asking a huge amount of around 1,18,000 something to implement the magistrate's order. Where the DCP was appointed, if a lordship may kindly see page 25, annexure 4.
Or 25?
25, annexure 4, 25, page 25. That is 6th April 2024 letter from the
Towards the
DCP
cost of the police deployment.
Yes.
to the authorized, to the security authority.
Hold on.
Cost of the police personnel to be deployed in connection with taking over possession of the mortgage property. As per your requisition, police assistance will be rendered during taking over physical possession of mortgage property, which stands in the name of the so-and-so. Under so-and-so Miller, the property consisting of land, they have given floor area and all this. An elaborate police arrangement will be made for maintenance of law and order. For smooth conduct of the physical possession of the property, the total cost of the police personnel to be deployed is 1,18,103. Please deposit the cost of police personnel amounting to 93,102 in the head of accounts also. Police supply to public and other parties, and deposit amount 6,986 in favor of head accounts also, contributing to pension and retirement benefits of other parties. And deposit amount 18,015 service tax GAT in favor of the Deputy Commissioner of Police headquarters. So, Lord, my humble submission for losses consideration is the obligation is on the magistrate, and the London magistrate
Under what
appoints.
provision you are challenging issuing this letter?
Pardon me.
Under which provision you are issuing, your DCP is issuing this letter to the petitioner that
Regarding
will
the cost
deposit
of
such
the-
amount?
Regarding the cost of the
Yes.
deployment. Can you kindly see page 18 here?
Yes.
18,
1
18.
Yeah.
The last but one para here.
Yeah.
A report compliance of the direction shall be filed in this court within a period of 2 months from today. Objection, if any, whomsoever consent shall be entertained before the DRT, and no objection shall be entertained in this court. Nothing stated in this order shall be construed in a finding of liability or judicial determination of the issue contention between the parties. The expenses for deployment of police personnel at the time of taking possession of the secured asset shall be borne by the secured creditor.
What is the rule position? What is the rule position?
That they have already deposited the
Contempt
amount.
it under the rule.
Well, nowhere in the act or rule says that we need to deposit the amount.
You can adjust it from the borrower. But why the state will bear expenses for financial institution?
No, well, not financial institution. My submission would be the obligation is under the land magistrate.
Yes, obligation, but
Obligation, but
24,
Pass the
see,
order.
you are a financial institution.
Page
Why the
80.
state will bear?
No,
You have to bear and you collect it from the borrower.
these small accounts are coming, for example, 10 lakhs, 9 lakhs, 15 lakhs, where a lakh of rupees to be paid to maintain law and order. Law and order is a state subject. And DCP is appointed as the authorized officer. Page 19, the next page, what my learned friend said. He himself is the
after all,
authorized.
are you
May I-
challenging the order dated
They
13 to
already
2024?
submitted those.
You have not challenged that order.
You are not questioning that order. That part of the order you are not questioning.
I am on the implementation. That's why I mentioned.
No, 13, that
Implement
issue is
implement
subset of first issue.
flows from that order.
Yes.
In the 13 to 2024 order, which was passed by the London CJM,
My lord.
in page number 18, there was a clear-cut direction that the expenses for deployment of police is to be borne by the secured creditor. That order as it stands now. So on the basis of such order, if they have quantified the amount to be 1 lakh and some odd, so what is the grievance of you?
They have already
The order as it
deposited
is
those
to be
amounts.
implemented.
So we kindly see page 27-20. They have already deposited those amounts.
Yes.
So
I'm
there is no national.
Yes.
What provision they are claiming.
Okay, the
I'm
second
repeated.
issue, please ignore the second issue. Come to
Okay,
the first issue.
Come to the first issue. So now they have deposited. What is the harm in
As it-
delivering the position?
So as it seems from the record, the last notice was scheduling the position, taking of the position on 21/4. I have to take instruction what step they have taken thereafter.
Taking instruction next week.
Because merely by issuing this letter to the
But
IIC.
they can approach the jurisdictional magistrate for that.
While they have deposited, there is an order. You have to-
Deposited, now you are to, in accordance with the law, you are to deliver.
I'll take instruction what steps they have taken.
This writ petition has been filed by the petitioner, so and so. With following reliefs, quote from the prior question. The Grand Counsel for the petitioner, referring to section 14 of the Surface Act and also to the citations use of Balakrishna Ram Tarle so and so versus Phoenix R so and so were reported in 2023. Contended that it was the statutory obligation enjoined upon the district magistrate to take immediate steps after receipt of the written application under section 14(1) of the Surface Act from the secured creditor and to take possession of the secured assets and documents relating thereto and to forward the same to the secured creditor at an earliest opportunity. It is contended that when the order dated 13/2/2024 was passed by the learning CJM, Cutter, in Miss Case number 43 of 2023. And specific direction was issued that the expenses for deployment of police personnel at the time of taking possession of the secured asset shall be borne by the secured creditor, the amount has been deposited by the petitioner before the opposite party number 3, Deputy Commissioner of Police, which would be evident from deposit
Page 27-20.
which would be evident
26/27/28.
from the documents annexed to Annexure 4. After receipt of the letter from the opposite party number 3 dated 6/4/2024. In spite of that, the petitioner has is not able to get the possession of the secured asset. And last time on 17/4/2025, under Annexure 8, opposite party number P issued a letter to IIC Chauliaganj Police Station, wherein oblique Mahila PS, oblique RI of Cuttack UPD, oblique SCP Zone V, Cuttack, wherein it was asked to the police personnel not only to maintain law and order during taking over the position, but to ensure that no untoward incident takes place. And the date was fixed to 21/4/2025 for carrying out the provision of the Surface Act 2002. Stop. It is the contention of the Land Council for the petitioners that in spite of issuance of such letter dated 17/4/2025 till date, the petitioner is not able to get the possession of the secured asset. Stop. The Land Council for the state has not disputed, after going through Annexure 4, that the amount which was sought for by the DCP Cuttack to be deposited has already been deposited, and the DCP has also asked the police officials to take necessary action. However, she submits that since in the meantime, more than 4 months have already elapsed, she may be given some time to obtain instruction as to why the petitioner has not yet been given possession of the secured asset, and if there is any order in that respect or not. Put up this matter on
10 days.
10th of September 2020.
Item 5.
Thank you, Lord, sir. On behalf of D. Manti, Mr. Manti is on accommodation. After me taken kind of next week.
I'm from opposite parties, sir. Any interim order was passed?
No, my lord, it's fine.
All right. What is your good name, Land Council?
Padin Kumar Naik. SK Naik.
SK Naik. Mr. SK Naik, Land Council, appearing on behalf of Mr. Devadatta Mahanti, submits that his senior is on accommodation and the matter may be taken up on some other day. What is your good name?
Sheikh Aziz.
Mr. SK Aziz, Land Council, appearing for opposite party number
2, 3, and 4. ICC
3 and 4 are present, is present. On consensus of the parties, this matter. They were
Next week.
Next week.
Sunday and given.
Next week, the Sunday token, 15th
Section 14 order has been changed.
15th September 2025. Next Monday we are.
Okay.
Item 6.
In this case, opposite partner 1 and 2 file a reply, my lord. But the copy has not sought, my lord.
I already found the question.
I have not received the copy. They have not sought. Let me, my lord.
Receipt as well.
Office रे दे दीजिए.
Office to leave in office to the office out the upon the bay.
Let me next week, my lord.
It's all right, you got it. Let me go. What is that called? Reply na कौन सी डालूं? File को तीन डालूं. ठीक है. It is stated by Mr. Nair, Central Government Council, that the caviter has filed a reply to the writ petition. Writ petition को reply दीजिए to the writ petition, but the same is not available on record with him. Stop. The land counsel for the cavator submits that the receipt is available to show that the copy of the reply has been served in the office of the Deputy Solicitor General. Stop. Mr. Naik seeks for an adjournment to verify the same. Put up this matter next week, maybe. Place this matter on 15th of September 2025.
One request, when he has filed
That
the
is
petition,
torn
he
back.
has not included the consolidated OA, which has been filed in Central Administrative Law.
See that
Where the annexes are
the
there.
short reply filed by the opposite
That
party
suppress the facts.
is available on record. Cavator opposite parties to them. Yes, next week, 15th.
Item 7.
Item 7, compromise talk is going on. May I play some time minutes after 2 weeks?
इडको ପାଇଁ କିଏ appear କରୁଛନ୍ତି ନା notice ଯାଇନି?
For that reason, that because before it may be settled.
All right, Mr. Udgata Land Council appearing for the petitioner submits that the matter may be taken up on some other day as the negotiation is going on with the opposite parties.
Between the borrower because. Between the borrower because. Not the opposite, but borrower.
Between the borrowers.
Borrower because bank has come.
Between the borrowers. Put up this matter when you want it.
But after vacation.
No. As prayed for, list this matter in the week commencing from 13th October 2025.
Okay.
Item 8.
After surface here, petitioner written loan from the opposite party given at 20 lakhs for construction of building. I told him he was paid 18 lakhs. He made a series of representation before the opposite party bank for settling the amount. But the bank as an either he takes step. In spite of that, he was taking a step.
Now auction notice has been issued.
Auction notice and he was
That was since long. You see the auction notice. That 31/12/2024. What happened to that?
That 24/8/2025, the Superintendent of Police issued a notice to the authorization for taking possession of the land.
Yeah, that means the auction has become successful. And
Auction not
Section 14, result of Section 14.
My lordship, as per my instructions, my lordship, the auction sale has failed, my lordship. Auction sale has failed, my lordship. Yes, my lordship.
Then how you, it was the notice was issued?
My lordship, that is under section 14, my lordship. The section 14 order was passed and now it is being complied with, my lordship. To take over the physical possession.
No, 14, who, bank approves the.
Yes, my lordship, collector, the DM, my lordship.
Already.
Who are you?
For the bank.
Permission, my lord, I am, let them sort the copy of the writ petition at the stage of the taking the physical possession of the property in question. For at the stage of taking the physical possession of the property in question, they have approached because the collector has already passed a specific order for taking physical possession and the amount has also yet to be deposited for the. By the
how
time
this is maintainable now?
that is this on 3/9/2025 we came to know that. Accordingly, we have only to stall our deposit.
You have alternate remedy.
Alternative remedy is there. Why?
That is the crux of the issue. When I came to know that, I finally
Go to the alternative remedy. The petitioner, Mir Bhuttu Ali, has filed this petition for consideration of his OTS application dated 4/8/2025 under Annexure 5 by the opposite party's bank. The Mr. Tuna Sahoo and Counsel appearing for the bank submits that in the meantime, the property has been placed to auction and the third party interest has been created or what?
Auction is failed, but the property in question yet to be taken physical
and-
possession of the strength of the collection
Since
order.
the auction failed, the bank approves the district magistrate.
Already
District,
in the order.
district magistrate, Bhattapna Kudiya.
Yes,
District magistrate Bhadrak under section 14 of the sub SIR, and the process of handing over possession to the bank is under process.
Yes, please.
And moreover, he submits that the writ petition, the writ petitioner has got alternative remedy. Therefore, this petition should not be entertained. So, in view of the settled position of law in the case of Soda, so there is a decision Soda. Since the petitioner has got alternative remedy, it is open to the petitioner to seek necessary remedy in accordance with law. Accordingly, the writ petition is disposed of. Yes.
Obliged.
Item 9. Your Lordship, I appear on behalf of my senior, Mr. Sambit Mahanti.
You are appearing for whom?
Mr. Sambit Mahanti, my
No, Sambit Mahdi for petitioner or opposite party?
I'm for the petitioner.
You are for the petitioner.
Counsel.
The opposite party, as we find, is
Yes.
one is Debt Recovery Tribunal, Limited, State Bank of India.
Yes.
Mr. Mahanti is appearing for State Bank of.
No, Your Lordship, actually, my another counsel has been appointed for this case. So I request you to
Are you mentioning in item number 8 or something?
9
What do you want? You want an
Item
delete-
number 9.
delete
Item. You are making a mention on behalf of Mr. Sambit Mahanti.
yes, Your Lordship.
Is he appearing for State Bank of India?
No, Your Lordship.
Then how this matter is not connected? The opposite parties are State Bank of India, State Bank of India. There are two opposite parties. Both are authorized officers, State Bank of India. Why are you mentioning this matter? This is not Mr. Mahanti's matter. You say
Item number 9, Your Lordship.
9 only. Which cause title you tell us? Tell us the cause title.
I only assigned for delete.
Madam, you must know that what is the case number for which you are making a mention. It may be that some other case your senior has instructed you
No,
to make a mention.
no, Your Lordship. Actually, is assigning for Kanishta Behra versus State, item number 9 of this court.
But you say that Mr. Sambit Mahanti is not appearing for State Bank of India. And how Sambit Mahanti is concerned with this case?
No, Your Lordship. My senior said me to delete his name from the case of Kanishta Behra versus State. Because
No name is appearing, madam. No name is appearing in the cause list. What is the question of deleting the name?
It
Somebody.
is in the second list.
Maybe.
Item number second list.
Second list means dita bade.
Oh, that is criminal matter, madam. It's over.
Second list.
highly op-
Criminal.
No, it's all right, all right. Please don't be confused. There are two separate lists are there. So it may be that you are
Yes,
mentioning.
me, so I.
Okay, it's all right.
Highly
Yes,
op-
go on,
Yes.
yes.
My lord, in this case, I have challenged the inaction of register DRT that not passing any order by my IA 793 of which I have filed for handing over the DD of 13 lakh which lies over prior to 26/9/2024, which I have paid as part payment of my outstanding dues. My lord.
What is the IA number?
IA number 79. It is under
What is
annex
DY?
DY8.
Diary
That
number.
is I have just a minute.
Diary number, maybe.
That is diary number, but
Defects in diary number.
no,
question,
when I filed that defect was not removed, that it was considered as diary number.
Now you have removed the defect.
Yes, and order has been passed, but it was rejected, my lord. That order I have annexed in 26th
page number 66, my lord. But that, my
Yeah,
lord,
just a minute, just let us understand. So essay number 55 of 2024,
yes, my lord.
it was filed by you.
My lord, challenging the order of section 14 of Sahoo.
Okay, then what order was passed?
And it is not, it is still pending, my lord, and order is passed to deposit a part payment according to the order of learned PO. I have deposited, my lord. And
Where is that order of
that is,
deposit?
if your lordship 626 page number, my lord, page number 37, my lord, 37.
Okay. No, that is dated 26/9/2024.
My lord.
But you said that an order was passed on, this is the latest one, 29/5/2025.
That is page number 68, my lord, 29/5/2025 order.
So the IA was disposed of.
Disposed of by rejecting my claim.
Perusal of the record, it is seen that the applicant has deposited the said in compliance to the order of this tribunal, and the matter is pending for final adjudication. At this stage, DDs cannot be considered, and the same shall be considered at the final disposal.
What is wrong in
So
it?
what is wrong? You want it that the final disposal should be expedited, or what?
No, my lord. My prayer was as per the by complying the order of learned PO, I have deposited prior to 26/9/2024 13 lakh as my part payment of outstanding.
It's all right. That is how the.
No, my lord, but now the order which were filed for return of DD to the remit back to the DD to the bank, now the IA has been disposed of, that DD to be returned to the applicant, my lord. Those part of my prayer was infructuous, my lord. But the only prayer your lordship may confine to my third prayer, my lord.
What is your third prayer?
That is, my lord, that is page number 17, my lord. Why the petitioner shall not be considered as a waiver of paying huge amount of interest imposed.
Make that application there.
The bank will do it. Then we waive your interest.
At that time when my
you have to approach the bank for waiver of the interest part.
Yes, my lord.
How can there be a mandamus?
No,
We are narrating you move an application for expeditious disposal of that essay.
And I'll file on this case to
whatever you want to do.
That this case will be considered on merit, my lord.
The writ petition has been filed by the petitioner Surya Narayan Chaudhary, inter alia, with a prayer for a direction to quash the order dated 29/5/2025 under annexure 4. 29 in essay number, in essay number 55 of 2020. No?
It's 24.
54 of 2024 under annexure 4. On perusal of the said order, it appears that the presiding officer has observed that the petitioner has deposited an amount of rupees 13 lakhs. 13 lakhs to deposit करछन तो
ଆଜ୍ଞା ସେଟା ମୁଁ prior to କିନ୍ତୁ but ସେ ନା bank କୁ remit କରୁଛନ୍ତି ନା ସେଟା ସେମିତି ideally even if the
just a minute.
Yes.
Wherein the presiding officer observed that one interim application was filed by IA DY number 898 of 2025 for handing over the DD amounting to rupees 13 lakh to the petitioner in order to deposit such amount before the opposite party bank. And it further appears that the bank, a submission was made by the bank that they have no objection on such prayer. The learned tribunal, however, held that the return of the DD cannot be considered at that stage, and it would be considered only at the time of final disposal of the essay. And the date was fixed to 26/2025 for hearing. Learned counsel for the petitioner argued that thereafter the case has not been taken up for hearing, nor the DD amounting to rupees 13 lakh has not been returned to the petitioner. Stop. Pleadings complete.
Pleading complete now.
It is further stated that the pleadings are complete. Argument sunani sollani na nahi.
Sorry, এটা এবে my lord recently an order has been passed.
Order pass ho jayega.
नहीं said.
Stop kar do. The learned counsel for the petitioner submits that in the meantime, after hearing was concluded, the order has been passed by the Debts Recovery Tribunal matter.
No, sorry. Hearing has not been completed in this. I am appearing in the DRT minutes.
Order.
In respect of interim order minutes,
interim order में जो final order essay रे pass ही.
No, no, essay रे final, but I.
Oh, हमें essay का तो बचा.
That is an interference. Sorry, Patrick.
It's still essay is pending.
Essay is pending.
You want an expedite hearing of that
Yes.
time. That's all.
In the meantime, pleadings are complete, but
The pleading is complete ही नहीं.
essay is to be finally disposed of. Stop. Since the pleadings are complete and the petitioner has deposited an amount of 13 lakhs by way of DD from it is for this petition, permitting the petitioner to move an application for expeditious hearing of the essay within a period of 10 days from today. In the event such an application is filed, the Debts Recovery Tribunal shall fix an early date for hearing of the essay and dispose of the essay at an earliest, if there is no other impediment. Accordingly, the writ petition is disposed of. It is made clear that this court has not expressed any opinion on the merits of the essay. Yes, next.
Item 10.
In Mr. Sahoo.
Petitioner has challenged the order passed by the DRAT Kolkata, wherein the DRAT Kolkata.
DRT order challenge করছেন
My lord.
17/7/25.
My lord.
Where is that order?
But annexure, my lord, annexure.
Annexure?
On page 2637. 2637.
Yeah.
Lord, whereby the DRAT Kolkata.
You are appearing for whom?
I am appearing for the opposite part number 1, my lord.
Opposite party number 1.
I was the appellant before the DRAT.
Okay, your application appeal has been allowed.
Allowed.
So have you given a copy of the writ
Yes,
petition?
Lord.
So on what ground you are challenging the order?
My lord, here, there are grounds there has been no procedural irregularity committed by the bank while conducting the auction sale of the property in question. No fundamental error has also been committed. By only the DRAT Kolkata has taken to the consideration regarding the debt calculation of the amount. The calculation of the amount which is the debt, such a debt is such a language is incorporated under a definition of the Surface Act and referring to the 2G of the RDV Act, my lord. So debt, the two proceedings, this is RDV Act and the Surface proceeding. There are two different, only in the DRT Act, under the RDV Act, recovery of the bank's dues with the personally guarantee. So far the Surface Act is concerned, my lord, only security interest to be enforced in accordance with the law. My lord, so for the, under the RTB Act, only the court of law will pass an
No,
order.
the e-auction sale notice has been passed.
My lord,
Whether in pursuance of such notice, who is the petitioner, the opposite party?
this is lonely, he's the lonely mortgager.
So that auction sale become unsuccessful or
I
what?
mean, auction sale was conducted fully and success, sale certificate was granted, and the delivery of possession has also been given on the terms of.
Who is that person? In whose favor that has been granted?
Party number 2, let's say.
Opposite party number 2.
Miller.
So he has to be hard. Notice has not been issued, I think, in this matter.
Notice may kindly be
All right,
issued.
this writ petition has been filed by the Union of Bank of India, challenging the order dated 17/7/2025, passed by the DRAT Kolkata on dated 17/7/2025. In setting aside the judgment and order dated 22/11/2024, passed by the London DRT, and also quashing the e-auction sale notice dated 20/2/2023. It seems that the opposite party number 1, Devendranath Das, approached the DRAT challenging the judgment and order dated 22/11/2024, passed in SA number 44 of 2023. Mr. Tuna Sahu, Land Counsel, appearing for the petitioner bank, submits that the auction sale notice, the auction which was held pursuant to the auction sale notice under Annexure 9 is
in accordance with the law.
Is in accordance with law, and third party interest
Has
already been created, and the opposite party number 2, Rakesh Kumar Malik, is the successful bidder.
My lord.
Stop. The Mr. Alok Kumar Das,
Yes.
Land Counsel, has already entered appearance for opposite party number 1, and he has received the copy of the writ petition. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice on opposite party number 2 shall be filed within a period of 1 week from today. Matter will be listed 4 weeks after. Date they will. Counter affidavit, if any, be filed in the meantime by the opposite parties. Yes.
In the meanwhile, stay of operation of the order, my lord, there are
IN number so and so, there shall be stay of operation of the order dated 17/7/2025, passed by the London DRAT Kolkata till next date. Yes.
obliged, develop.
In case number 5.
Item 11.
These are not.
He also.
No,
What interest is without.
Good. Yes.
This is regarding earlier lordships had heard this matter, though my learned friend Mr. Agarwal was not present that day. This is ED's eviction notice.
That is Mr. Agarwal.
Yes, so your lordships stated that it should go in appeal. So we had agreed to that proposition, but that 45 days period at least that we should be protected because they have given only 10 days time. It was in the eviction
If
notice.
the statute gives 45 days, by 10 days? Huh? If there is an adjudication order, appeal can be filed within 45 days
Page
for
15,
PMLA.
PMLA.
What they have done?
They have given only 10 days.
10 days,
Can
10
you
days.
notice, see page 15.
15. This is order dated 14/8,
14/8.
2025.
Yes.
10 days time.
Yes, Mr. Agarwal, you have to say why special treatment?
देखिए पति ये अपील पीरियड था
Yes, 26 3-year lawsuits.
Lord, here the sole ground he has taken that she had no knowledge about the.
No,
we are not on
Merit, we are not on.
That always he can file as per law.
But he says that why 10 days? That
No, 10 days is a different provision, my lord. Appeal is under section 26. That your lordship kindly see annexure 4.
Which you would have challenged this order dated 14/8,
Yes, my lord.
2025.
Section 26, your lordships may see.
26.
PM. PM.
That is appeal to appellate tribunal.
Appellate tribunal.
Yeah.
26(3), if your lordships would see, shall be filed within a period of 45 days from the date on which a copy of the order.
Save
made
as
by the
otherwise the
adjudicating
director
authority
or
the
any
director.
person aggrieved by an order made by the adjudicating authority.
Or director.
So this is passed by the adjudicating.
By the director, deputy director,
Deputy director.
for so far as the eviction notice is concerned.
So this period is said that it is 45 days. Okay.
Only that we want subject to.
Let him go and
No,
file
my
the
lord.
appeal.
My notice, that notice is under the rules, my lord. Original order was passed and they are filed under annexure 4, my lord.
If you please come to that eviction notice.
Yes, my lord.
It was issued under section 4 of section
Eight.
8 of the Prevention of So and So Act.
Yes, my lord.
So this, under this act, if any such notice has been issued by this authority, deputy director,
No, my lord. What-
are you disputing that appeal
May I
does
clear-
not lie?
No, my lord.
Where is the adjudicating author?
My lord, under
authority's order?
section 5, provisional attachment order is passed. And then original complaint is filed before the adjudicating authority. Or the adjudicating authority, your lordship kindly see annexure 4. They are filed along with the
Where is that?
annexure 4, my lord, they are filed along with an additional affidavit.
This is the adjudicating authority's
No, my
order.
lord, no. This is my
This is the
letter
subsequent
after
eviction.
confirmation, my lord. After
Your lordship-
confirmation, please. After confirmation, my lord, we have directed him to vacate the premises. This is that notice. The confirmation order is under annexure 4, my lord.
Let us be very clear.
Yes, my lord.
Your
The-
lordships may see 8(4).
Adjudicating authority order ta kuta.
Annexure 4, my lord.
Annexure 4.
What is the date?
What is the date of that order?
That is 23, my lord.
3/7/23.
Just now, just. So, 3/7/23.
23.
Yeah. Then
So
the
then-
limitation,
No, my lord, that is a
Recall from
separate
that day.
issue. That is the separate issue whether what I challenge, because if your lordship should see section 8(4), what are the orders that can be, my lord, passed, and if that order can be
no, this
appealed
that
again.
this is the attachment order is a consequential order to
I
the,
understand, my
the
lord.
order of
Both the-
adjudication.
Both the orders are appealable.
You can file an interim application there.
Then, no,
Have you filed the appeal or not?
no, not yet, because that
If you
45
don't challenge
days
that
is-
order, then the consequence will follow.
45 days is not yet over, because
No, it is
that is
2023 order.
your lordships may come to 8(4). I'll just take your lordships for a moment to 8(4).
If you find the operative part of that particular order,
Yes.
annexure
4.
4, you'll find in paragraph number 12,
The attachment is confirmed by the adjudicating authority.
mention that the attachment of.
Attachment is confirmed.
Yeah. The ideal situation would have been, you would have filed an appeal against this order,
that
and the
time,
attachment
my lord,
would have been challenged by a
That
miscellaneous
time the
application.
petitioner was in custody. That time the petitioner in fact was in
That could
judicial
be a
custody.
ground for condonation
So,
of delay.
yes, but my lord, this order also under 8(4), the eviction order what has been filed or what has been served now on me, if your lordships may just for a moment come to 8-4.
Without there being a challenge to the
No, it
adjudication
can
order,
be
how do you
both.
challenge the
It can be
consequential order?
both. That is why, my lord, I am saying it can be both. If your lordships just have a
This is
glance at
consequential.
8-4, may I take your lordship?
8-4 of what?
PMLA Act.
This is a consequential order. Yes, 8-4.
Where the provisional order of attachment made as subsection 1 of section 5 has been confirmed under section 3, the director or any other officer authorized by him in this behalf shall forthwith take possession of the property attached under section 5 or frozen under subsection so and so in such manner as may be prescribed, provided that if it is not practicable to take possession of a property frozen under section 1A of section 17, the order of confiscation shall have the same effect as if the property has been taken possession of. So now they want to take possession by virtue of this eviction notice. Then 5.
Just a minute.
26-3.
Yes.
Then 5, your lordships may say. Where on conclusion of a trial of an offence under this act, the special court finds that the offence of money laundering has been committed, it shall order that such property involved in the money laundering or which has been used for commission of the offence of money laundering shall stand confiscated to the central government. So that is post-trial confiscation.
Yeah.
So in the meantime, so any order which has been passed by the director under 8-4 can also be appealed against. And along with that, I will challenge both.
Without challenging the adjudication order.
Both, because here also I have challenged both the orders.
Challenge.
Not, so
But
that
the
is
limitation recon from the date of adjudication order.
That is the statute making.
no, my lord, that I don't say no. But the question is, even on the eviction also, if that, because any order, because this section says, appeal section says, any order filed by the director.
File it now.
So 8-4.
The writ petition has been filed by the.
This notice was under rules, not under the act.
All right.
Rule cannot, my lord, override the statutory provision of the act.
The order dated.
That's the basic.
The eviction notice dated 14/8/2025. 14/8/2025, that is under annexure.
That is, my lord, part of annexure 1. I'm sorry, my lord. Yes, annexure 1 series.
14/8/2025 passed by the deputy director.
Consequent to the
Consequent to the order.
provisional attachment order.
Provisional attachment order passed under section 5(1) of the PMLA Act
Dated
dated 9/2/2023, issued by the Deputy Director, Director of Enforcement, Bhubaneswar Zonal Office.
That is the
No, my lord, that was
That is the
the
adjudicated.
provisional, your lordships are mentioning. Then the, my lord, final order has been passed on 3/7/2023.
Pursuant to that 3-7.
Pursuant to the
3-7, what is that?
Annex
7/2023 Annex
Second
4.
has been passed. Sedauchi Roman 2 Roman yes. On perusal, the Mr. Nandal and senior advocate appearing for the petitioner raised the first point that when the eviction notice has been issued by the deputy director on 14/2025, and the statute provides
Under section, you will also mention 8-4.
under section
Under section 8-4.
under section 8(4), and the statute provides under section 26(3) of PMLA Act that the person aggrieved by an order made by the adjudicating authority may prefer the appeal to the appellate tribunal
Or
and,
director, my lord. Adjudicating authority or director, both are
the
there.
person aggrieved or the director, no? The director or anybody, to the appellate tribunal, and within a period of 45 days from the date on which the copy of the order was made by the adjudicating authority or the director is received, comma, it was and the order was passed on 14/8/2025, comma, it should not have been reflected in that order that the petitioner has to vacate the scheduled property along with the furniture, fixtures intact as on date of attachment and hand over the peaceful possession of the said premises within 10 days from the date of receipt of the notice. Inasmuch as after inasmuch as the petitioner has got a time limit up to 45 days to challenge such eviction notice along with the order dated, the final order dated
Provisional attachment at confirmation.
3/7/2020.
Provisional attachment.
No,
Provisional.
the attached, final attachment is 3/7.
3/7.
This provisional attachment merges with that.
Yes.
the final order of attachment dated 3/7/2023. 2023.
Yes.
Stop. Mr. Gopal Agrawal, senior advocate, appearing for the
Both OP number 1 and 2.
both OP number 1 and 2. On the other hand, submitted that the appeal which has been prescribed under section 26 of the PMLA Act is
Against final order.
is against the final order
Confirmation by adjudicating authority.
and to be passed by the adjudicating authority. And in the case, the final order is dated 3/7/2023, which should be evident from Annexure 4. And admittedly, the petitioner has not challenged the order under Annexure 4 within stipulated period of 45 days before the appellate tribunal. And the eviction notice is a consequential order.
As per Rule 5 of
as
the
per Rule 5(2)
5(2)
of the PMLA Act.
Prevention of
PMLA
money
rule
laundering,
is
possession of attached.
PMLA bracket annexure taking possession of the attached or frozen properties confirmed by the adjudicating authority bracket ends Rule 2013. And therefore, it cannot be said that there is any illegality on the part of the authority in fixing the time limit of 10 days for the petitioners to vacate the premises as per eviction notice dated 14/8/2025. Stop. Adverting to the contention raised by the Land Council for the petitioner, let us quote the relevant provision. Stop. Under 26 of the PMLA Act, which reads as follows, quote so. This order, this provision makes it clear that the 45 days time has been prescribed for preferring appeal against the order passed by the adjudicating authority from the date when such order has been received.
It has been mentioned or director, adjudicating
Or that part of that.
or
For
the
either.
director. And in the case, the said order, final order has been passed on 3/7/2023, and admittedly, no appeal has been preferred by the petitioner within the stipulated period of 45 days. And it cannot be also and there is no dispute also that the eviction notice dated 14/8/2025 was consequence of the order dated 3/7/2023 passed under Annexure 4. Mr. Nandal and Senior Advocate submits that the order under Annexure 4 could not be challenged within the stipulated period as the writ petitioner was in judicial custody, and after he was released from custody, he has referred this writ petition challenging the orders of the confirmation of attachment by the adjudicating authority dated 3/7/2023, as well as the eviction notice dated 14/8/2025.
But my lord, she appeared before the adjudicating authority, filed their so called
Stop.
after hearing that order.
We are not entering into that, just we are recording this
Yes,
submission. Mr. Agrawal and Counsel, Land Senior Advocate on the other hand submitted that the petitioner very well appeared before the adjudicating authority and filed his objection, and the matter was decided on merit. And the ground of stop, considering the submission made by the Land Council for the respective parties, since we find that the appeal provision is available under the statute challenging the order dated 3/7/2023 asked by the adjudicating authority, PMLA, to also the consequential eviction notice dated 14/8/2025, we give liberty to the petitioner to challenge such orders, and with a delay condonation application indicating the delay in approaching the
14/8 order cannot be challenged. Against confirmation order, appeal is provided. If he could have gone there.
He says director, this is a director.
No, director.
Let him do whatever.
14/8 order cannot be challenged.
We are not entering into that.
We'll simply say that it is open for the petitioner to challenge both the orders.
He can challenge, that's a different question.
To the petitioner to challenge both the orders.
We'll not
It
say,
made
we'll not
clear
deal
that
with
we
it.
have not expressed any opinion either on the merits of the order dated 3/7/2023 or whether the delay to be shown by the petitioner for entertaining the appeal is to be condoned or not. It is open to the authorities to consider the same in accordance with law.
In fact, he says the independent appeal doesn't lie against the notice.
Yes, my lord.
That's what he says.
This read is also not maintainable, my lord.
He's true to that extent.
It is maintenance, but also for
It is not-
petition is concerned, the Supreme Court direction is also there.
Next,
Since we
You
are-
can't maintain an appeal against a notice.
Yes, if till such time within a fixed period, your
Anyway,
office
that
may
is your
say
out-
within 4
Oh,
weeks. And till such time it can be protected.
we're already late. Next.
Item 12.
And for the petitioners, my lord, the petitioners are challenging.
Yes,
And for the petitioners, my lord, the petitioners are challenging the arbitrary action of the opposite party bank of non-consideration of the statutory representation filed under 13(3) of the SARFAESI Act. So what has happened here is, my lord, petitioner 1 is the guarantor, petitioner 2 is the borrower, and they are running an MSME entity and they had availed a loan from the opposite party bank.
E-auction cell notice has been issued.
My lord?
E-auction cell notice.
Yes, my lord, yes.
Has been issued. So you have got alternative remedy. Go there and challenge the.
My lord, the only difficulty is that the auction is scheduled for today only.
Yeah. Participate in that auction.
My lord,
my only grievance is that I have been repeatedly making my statutory representation under 13(3)(a).
The Miss Swan, so the petitioners for them. Challenging.
Auction, my lord, even if it is for today, takes 15 days time for confirmation of sale. So that time is sufficient to approach the DRT.
On the ground that the representation submitted under section 13(3)(a) of the SARFAESI Act has not been considered in accordance with law. Stop. It appears from the pleading that the e-auction cell notice under Annexure 8 has already been issued, and today is the date fixed for the e-auction cell. Stop. In view of the decision of the Honorable Supreme Court in case of so and so, since alternative remedy is available to the petitioner to challenge the e-auction cell, we are not inclined to entertain this writ petition, which is accordingly disposed of. Yes,
my lord, if I may, my only prayer is that before taking any coercive action, my consideration may be taken into account.
To the next decision.
All those grounds are available in the DRT, my lord.
Item
13.
My lord, may I pray my name may be recorded, Mr. S.S Mishra. I am the standing counsel for UCO Bank now.
Thank submission for submit that since petitioner has got alternative remedy, this writ petition is not maintainable. Proper law decision date is being. Yes.
Item 13. I am petitioner. Petitioner challenges auction sale notice published on 12/8/2025, page number 11, Annexure 1, my lord. On the ground that the bank, without verifying ownership of the residential property, financial loan in favor of opposite party number 3.
The auction sale date is already over. 29/8/2025 was the e-nilam ro tariko ebong to kon hela 29/8/2025 रे kon hela
हेलो ସେମାନେ हमको नोटिस देले 25/8/2025
ये जो ई ऑक्शन रो जो नोटिस हेइथिला एवं धार्य हेइथिला ई नीलाम तो फाइनल तारीख होची 29/8/25 जदिनो कोन हला नीलाम फाइनल हला ना फाइनल फेलियर कला ना थर्ड पार्टी इंटरेस्ट क्रिएट हला कोन हला अपन ऑपरेट इंस्ट्रक्शन कोन
I filed petition, show my lord move case file was pending.
26/8/2025 you filed.
Union Bank of India matter.
Yes.
So I'm just
कोन हला
my lord, I will take instruction only 5 to 10 minutes. I will whether the auction has been filed or
pass over करतो
just
next.
Item 14.
May I please?
No, this is a case, my lord. OTS application has been filed, my lord, page 44. In the meantime, my lord, they have issued e-auction notice. That is, my lord, page 47, Annexure 14. The property is, my lord, 480 square foot only. Only one. And I have given OTS, my lord, for 10 lakhs. And both are, my lord, heart patients.
No.
Sympathy is
only that.
your side, but
this honorable court has shown sympathy. This honorable court has shown sympathy. And pursuant to that manner, I have paid 10 lakhs of rupees.
Sympathy देखेगी नहीं सेठी observation होची जे better.
Here, my lord, it's a 480 square foot only.
Alternate, so file this one, alternative remedy mechanism. I will put this one should have put for in disposal problem. Mr. Tripathi, senior advocate. Yes.
E-auction टा अच्छी 25 नको. Can it be taken up after that so that the 32 लड़कियों की 9 को आसी है.
No, that's good for you. Next. Yes.
Item 15.
Mr. Rao?
Yes.
What is this?
Here, what has happened? There was a one-time settlement. The settlement was accepted, and I have deposited sufficient money. 1 crore 90 lakhs, it was accepted. I have paid up to 1 crore 20 lakhs. And then I gave a letter to them saying that I am not able to pay the balance. Please grant me some time. They have rejected that. Therefore, I have come before your lordships, and they are now they are saying that the OTS has been cancelled because of non-compliance of the terms. But my submission before your lordships is the OTS has been approved.
Any surface side proceeding has been carried out, Mr.
So now I got the information to appear in this case, my lord. I will take instruction whether.
Just give a copy so
I will
that
do. I will come.
Mr. Anjan Kumar Biswal and counsel submit that he has instruction to appear for the Punjab opposite party, Punjab National opposite parties banned for them. Let a copy of the writ petition be handed over to Mr. Biswal, who will obtain instruction in the matter. Se kebe rakhiwa kon se deichanti deposit korchanti substantial amount agita
20 lakhs we have deposited.
kete tar outstanding achi kemti kon kari hobo positive gote within in darkar to we can has not been complied with according to you.
General,
In a
already.
PL matter, there was a direction.
Yes.
In accordance with direction, the petitioner filed a representation before the authority,
Yes.
Tahsildar. And in pursuance to that representation, Tahsildar initiated a miscase, measured the land and found 1 acre some odd. I am filing a compliance affidavit, my lord.
The contempt application has been filed by the petitioner
And OPLE proceeding was also initiated against the
with
enforcer.
a prayer for implementation of the judgment dated sworn to. The land council for the state, on the other hand, will do the compliance affidavit
Filed by the Tahsildar Khorda.
filed by the Tahsildar Khurda, annexing the joint inquiry report along with this case map, the notice under form K.
Cause.
And the order sheet in this case number 173 of 2020. I'm going to copy this. The
Representation also disposed of.
affidavit has been served on the land council for the petitioner. In view of such compliance affidavit, there is contempt petition which is disposed of. এটা গোষ্ঠীর ম্যাটার রয়ে গেল যে কইলে দেখিয়ে দেন ইনস্ট্রাকশন আসে না we are just coming with this.
Item 17.
You know, we have filed a petition for recall of a compromise made between the petitioner as well as the Odisha Housing Corporation. In the meantime, they have filed an objection. So we want to file a reply to that objection. So, Lordship, I pray.
May I just your Lordship, may be kind enough to give me 2 minutes time. Lord, this is a shocking case. Not shocking to the writ petition was disposed of on compromise. Compromise with the public body.
When it was disposed of?
2018. And and with the public body, with a very senior IS officer at its head, and consciously they filed. They took legal opinion from a very senior counsel of this honorable court, and all those documents were there. Compromise was recorded. But there were certain directions. There were certain to pay these things, to give possession of these flats. All the stipulations have been complied with by them, except one stipulation: delivery of 6 flats, which are numbered in the numbers have been given. When we filed a contempt, they come up with a plea that since those flats are under orders of stay in
Direction number C is not complete.
Yes. So orders of stay we cannot give. So ultimately those cases were disposed of. Stay orders were vacated. A positive direction was given in the contempt that now there is no stay order, there is no impediment, you give the. Then they said that we are taking time, we'll give you shortly. These affidavits were filed by the author of the compromise, who was the then MD. The subsequent MD has filed a petition saying that it's very shocking that he was in a busy schedule. He was not in a fit set of mind. Someone got his signature there, and it. But this actually, this is something.
Millard, what happened? The MD who has signed it by the instance of the one company secretary, because it is a company.
Supposed to take evidence about.
Millard, because the MD has no power to go for a compromise unless the board directs them, unless the authority has been board. But whatever they now disclose in their reply, that is a meeting in the board. MD was not there. As per the quorum, directors are not there. Then by virtue of that, these
Have you taken any action against the MD?
Millard?
Have you taken any action against the MD?
MD action has not been taken because Millard, only thing
he has done something.
Who is saying? Who is saying?
The capacity MD is in charge of the organization.
Have you show us any action has been taken by the author of
we have taken against the company secretary, and who has
who is the author of the
the author of the is MD, no doubt.
You can't find a scapegoat.
No, Millard. Millard, if it is a wrong, it is illegal. So definitely we have the right to bring to your lordships, and will show you lordship that without having any authority from the board, because it is a corporation, it is not the government. The secretary has signed it, and it is then secretary has been authorized. But because it is MD, without having an authority of the board, and they have passed. So that document now, what they are saying, it is not a board resolution.
Then
MD otherwise, if any wrong,
MD has signed it without authorization.
Yes.
Why have you not taken action against the MD? Answer it.
That I will come, Millard. What action has been taken?
Then we will entertain.
Millard, only action has been taken against the company secretary.
Why have you filed an affidavit?
What action you are taking?
No action has been taken, Millard, but action has been taken against the company secretary.
Against the scapegoat.
But that is why saying,
find out
Millard, it is illegal order. If somebody has signed, definitely.
If it is an illegal order, the forum is something else.
Millard, because here the order has been passed, he has signed, because law itself says he has not been empowered. He has not been authorized. So if anybody, then further, if anything is unlawful, the unlawful should not continue. And that should not be given into a conclusion on the basis of that we have not punished or not punished or going to punish, something like that. So my view is allow us to file a reply, and thereafter your lordship take a call on this.
we expect the judicial process should not be taken so lightly by at least the organizations.
No, that is there. Because
we can understand.
there is a number of MD has been punished. Before that, one MD has been punished because it is a rural housing corporation. They are not aware about the mechanism how to give the loans. Now the company is in winding up mode. Virtually 4 or 5 employees are there. So my humble submission, your lordship may allow us to file a reply what they have given, annexing a resolution, and that we are going to challenge, and thereafter your lordship may take any action. Humble submission before lordship. Only 2 weeks time may be given so that we will give entire details what happened and how the resolution has been passed in connivance where no directors are present.
You are appearing for.
I am appearing for my on instruction.
Rural housing development. OP1.
Orissa Rural Housing.
Millard.
OP1.
Why LIC is a party?
Because LIC Housing Finance both have given loan, that is a pari passu. That is why they have been implemented as party. So it is a long.
Which application you have filed?
I have filed application IA number 5672 of 2018.
That is to recall the order dated.
Millard. Order dated 1 minute.
23 2018.
Millard. 20th March 2018.
What you have, they have filed objection to the interim application.
Millard.
So where is that? Let us see that. IA number. IU for SL. IA number 5672. Okay. Then as it appears, counter affidavit has been filed by the petitioners to the said IA.
Yes.
Right. Then another interim application has been filed for intervener.
My lord.
Okay. Who has filed? Sunita Sahu.
My lord.
Okay. Then an additional affidavit has been filed on behalf of opposite party number 1. Means this
rural housing bill.
Then what further you want?
Millard, in that we have stated that these connivance was
No,
there,
you
and
said that you want to file something else.
now they have filed an objection to that.
Objection they have filed since long. That counter affidavit you are telling.
Millard, now they are filing an objection to this IA.
To the additional affidavit which they filed, which is by the subsequent incumbent. Not kindly mark, the author of the compromise is not saying that. The subsequent incumbent has filed an additional affidavit saying all this.
This is
because he is in charge.
This counter affidavit filed by the petitioner. The additional affidavit.
Yes, that which your lordship had taken note of.
Oh, additional affidavit. It has filed is opposite party number 1. So to that you have filed this counter affidavit. Because you want to file a reply.
Millard. Simply reply to that after your lordship. Whatever the
my anxiety is they are dealing like this. They're saying that they cannot give. In the meantime, I have given in that disclosed in the affidavit that in the meantime they have advertised to sell 11.
Millard, that is not in the disputed flats. That is
disputed.
That is purely our flats. And even if you are dissatisfied, then we are 13 under surface.
If these 16 flats, if you start selling them.
No, these 6 flats. No. These separate.
The order is you give them these 6 flats or any commensurate flats.
Because several flats are
if they say
purely of the housing corporation, we are going to sell.
Flats which are numbered already in order.
Yes.
Those things will not.
No, because if they are aggrieved, they should go to DRT and file essay. But actually,
I am not aggrieved by it. Then look, I am bringing to your lordship's conduct. They are saying nothing is available, but they are going for sale.
No. But question is whether that 6 flats or 5 flats which has been sold by the owner through power of attorney and by the builder. So we are saying already it has been allotted. You will say I will argue, Millard, only because only give the time. What we are saying that compromise itself is unlawful and it has been in connivance has been done without the permission of the board. That we will bring to your lordship's notice. Just give one week or 2 weeks.
What is the managing director's power is enshrined in the Companies Act. Either by operation of law or by resolution.
Unless you take action against the author of the settlement, we may not.
No, Millard, that may observe, but after my filing, your lordship may take it, whatever the decision, but only my prayer allow 2 weeks time to file.
IN number 5672 of 2018 is an application for recall on the order dated 23/2018, passed in WPC number 9109 of 2005 and Miss Case number 3675 of 2018, wherein the division bench of this court disposed of the writ petition, taking into account the submission made by the Learning Council for both the parties that the matter has been amicably settled or be compromised, and as per the terms of the settlement, and also vacating the interim order dated 19/11/2009. The interim application has been filed mainly on the ground.
May I just intervene for a moment? Sorry to interrupt. Mainly on the ground, you said, kindly see the paragraph E of that recall application. That is the reason they are given. Paragraph E, just for a moment. That is the reason for recalling.
On the grounds.
So that inadvertently filed without understanding the complete economical financial complication.
Indicated in paragraph 4 of the interim application. Stop.
E. Paragraph 4E.
Counter affidavit has been filed by the petitioner to the said interim application. Stop. IN number 3010 of 2025 has been filed by one Sunita Sahoo with a prayer for intervention, and additional affidavit has been filed by the Orissa Rural Housing and Development Corporation, opposite party number 1. Stop. Today, the Land Council for the petitioner has filed counter affidavit to the additional affidavit filed by the opposite party number 1, dated 7/3/2025, which was taken on record. Copy of such counter affidavit has been served on the Land Council for the petitioner of the interim application. Stop. Who seeks some time to file his reply to the counter affidavit and pays for an adjournment put of this matter on such and such day. Stop. Reply, if any, be filed in the meantime, serving copy on the Land Council for the petitioners in advance.
No, my anxiety is that they are going for sale. And ultimately they will tell we have no flats left.
No question, that is purely separate. This is not involved in the dispute.
It is made clear that till the next date, the flat numbers which have been mentioned in the order dated 23/2018 in paragraph number C,
C,
shall not be sold to anyone. Yes, next.
You lordship seen that paragraph E.
C. Flat number.
Without understanding the senior as officer.
That will decide on that case. The other day. Yes.
The intervener copy. I'm sorry.
But intervener after disposal of the writ petition, I have no connection with them. I am connected with only.
Purchaser of flat number 428.
But
which has been spoiled by the build on the strength of the power of attorney.
Intervention applications shall be considered on the next date. Yes. Next.
Item 18.
May I please file? Lord, the last occasion I have taken time to file the VNMS. My lord, I filed 5 VNAMAs. There are total 9 appellants in this case. My lord, I am yet to receive 4 more VNAMAs. So, my lord, I pray for a short adjournment.
One to four state accepted the notice.
Yes.
So for 5, 6, and 7, we fixed the date of appearance to 1/9/2025, and it shall be served by on the respondent number 5, 6, and 7 through IAC of Go Police Station, and the compliance report shall be filed by the next date. State Council shall pass necessary instruction to IAC Go Police Station in that respect. You are appearing for whom?
I am appearing for the appellants, my lord.
No, appellants is long. Respondents katha kaun karo? Mr. Have you seen the order dated 18/8/2025?
Yes, ma'am.
18/8/2025 page 2 ku asantu. We have said that the IIC Go Police Station shall serve the notice on the respondent number 5, 6, and 7 and submit the compliance report. So where is the compliance report?
My lord, in this case, I am filing fresh VNAMAs. So,
Please wait.
It has not received, my lord. One short date, my lord.
Who is you are appearing for whom?
my lord, I'll be appearing for all of those appellants, but I have received 5 of them and I have also filed those VNAMAs, 5 of
Just a
them.
minute. Read appeal. There are total number of appellants are 10 in number.
Yes, madam.
Yes.
I have filed 5 of them. I am yet to receive 5
Five
of
means
them.
5 and 5.
My lord, appellant number 3,
Just a minute.
3, 6,
6,
8,
8,
9, and 10.
10. Who has filed Wakalatnama?
My lord, Shruti Aradhana Mahanti.
this
It is
this is nice.
Sanket Kanungo
Yes, ma'am.
Wakalatnama file.
Yes, ma'am.
Along with the associates, right?
Yes, ma'am.
So,
One memo also filed. The appellant number 7 died.
ଯାହା ବି ଆପଣ ଏକାଠି ଆଣିକି ଦଉନାହାନ୍ତି ଇନଷ୍ଟ୍ରକ୍ସନ ଆମେ ତ କହିଛୁ ବାକି ଯୋଉ ରହିଗଲେ ଯୋଉ ରେସ୍ପଣ୍ଡେଣ୍ଟସ୍ ତାଙ୍କୁ ଆଇଆଇସି ନୋଟିସ ସର୍ଭ କରିବ ଆଣିକିନି କମ୍ପ୍ଲାଏନ୍ସ ରିପୋର୍ଟ ଦବ ତାଦେହରୁ ଯଦି କାହାର ଡେଥ୍ ହେଇଛି ତାହେଲେ ଦଉନାହାନ୍ତି ରିପୋର୍ଟ
ଏଇଠି ଅଛି ମେମୋ ଗୋଟେ ଅଛି ମେମୋ ଫାଇଲ୍ଡ ବାଇ କାଉନସିଲ ଫର ଦି appellant at Flagger stating that appellant number 7 died.
ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ ସେ କଣ ଦେଇଛନ୍ତି
My lord, my lord.
Shruti Aradhana Mahanti is not there for this appellant number 9. He is there for the other appellants 3, 6, 8, and 10. Appellant number 9 ro Wakalatnama. Then you see this Wakalatnama of the appellant number 9.
Yes. Yes, my lord, says there.
Shruti Aradhana Mahanti. Achi. What is your good name?
My lord, Soumya Ranjan Paikrai, SR Paikrai.
Mr. Soumyaranjan Paikrai submits that Shruti Aradhana Mahanti and her associates have filed power for appellants number 3689 and 10. Stop. So more time is required for filing power for the rest of the appellants. Stop. Mr. Naik and additional government advocate seek some more time to produce the compliance report regarding service of notices on respondents number 5, 6, and 7. Put up this matter with the date.
The date fixed so that I will, in the letter, I will write a date may be fixed.
So that you can get the date on in the evening.
Well,
okay.
Item 19.
Yeah, Mr. Naik, it is your matter.
my lord,
The read appeal and there is
my lord, neither
delay
ready
confirmation
nor,
application 91 days.
yes, my lord. Neither ready nor on delivered notice back from respondent number 2. In this regard, postal tracking report, item delivered. So it is
Sufficient.
my lord.
Though AD nor the undelivered notice is back from respondent number 2, but the postal tracking report at flag X shows item delivered. Therefore, the notice on respondent number 2 is held sufficient. You are appearing for whom?
Respondent 1, my lord.
Is your objection file
No,
करचेंगे? You don't intend to file. IA number 886 of 2023. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 91 days in filing this writ appeal. The learned counsel appearing for the opposite party, respondent number 1 submits that the respondent number 1 does not intend to file any objection to the delay condonation application. Stop. After hearing the learned counsel for the parties and perusing the grounds taken in the interim application, we are inclined to condone the delay of 91 days in filing this writ appeal. Accordingly, delay is condoned. IA is disposed of. The writ appeal be placed for admission on what date they will. Yes.
Item 20.
Mr. Arupashad Panda. Review petition.
Steps for limitation not taken.
Dushman Kumar Behra. Judgment dated 29/4/2020. Order of appointment. ଆପଣ ଜାଣିଛନ୍ତି ଯେ ହରପ୍ରସାଦ ପଣ୍ଡା କିଏ?
No, my lord.
ଏ ପାହି
No, no, only Haraprasad Kumar. Previously, Mr. Samant Ray. Previously, Mr. Santosh Kumar Samant Ray and his associate filed this case, subsequently to us transferred.
the petition was dismissed way back in now the delay has been pointed out by the stamp reporter. Is it 1669 days? 1669 दिन.
And no limited count.
No, we do not know this how this is shown. Acha, यदि judgment ହେଇଛି 29/4/2020 रे and the review petition was filed on 15/5/2020, how it has been shown that the delay is date of presentation देखुची कौन 23/12/2024 माने कौन valid presentation. ODA file is a valid presentation form
Presented on 15/5/2020. 15/5/2020.
हाँ किंतु जो SR तक पड़े इसलिए लेकिन जब presented on 23/12/2024 से कि पाई 1669 दिन दिलाई जी सी तो मासे भीतर फाइल करची.
Limitation petition टा नहीं सच्ची पे बता.
No, limitation
Filed on 2nd November, September 2020.
The 1669 days will be
We know
it's all right, he is not there, but we want to see that whether the limitation has been rightly shown or not. कारण यदि review petition टा file ହେଇची same year रे
23/12/24 रुपये की कोड.
हाँ 23/12/24 कोड असला ये.
Where from this was?
That पचार दलाटा better now. मतलब order pass ହେଇची.
You see, the review petition here, it is written, presented in the court 15/5/2020.
ଏଠି ପୁରା ଲେଖା है ये जो first page ରେ ସେଠି ଲେଖା ହେଇଛି ସେ 15/5/20
Press report.
Non appears for the petitioner. The review petition has been filed by petitioner Dushmant Kumar Behra. Challenging the judgment dated 29/4/2020 of this court passed in WPC number 14746 of 2018. It appears that against the aforesaid judgment dated 29/4/2020, the petitioner filed the review petition on 15/5/2020. However, the stamp reporter has mentioned that the date of presentation of the review petition is dated 23/12/2024 and accordingly shown that there is delay of 1669 days. Stop. Let a fresh report be submitted by the stamp reporter as to how, in spite of the presentation of the in spite of the filing of the review petition on dated 15/5/2020, how it has been shown that the review petition was presented on 23/12/2024 and therefore there is a delay of 1669 days. Stop. Put up this matter in the week commencing from 15th of September 2025.
I think you should raise I would have submission to make it that
Which item?
that writ appeal which has been concluded hearing,
Yes.
the Lordship has fixed for orders,
Yes.
delivery of orders. Your Lordship directed the government to, not the government, MCL to file the
MCL.
affidavit. So the affidavit copy has been served on me. If your Lordship kindly say it has not been in consonance to your Lordship direction. So your Lordship have to look into that. They must comply your Lordship direction.
We have passed the order that number 1 and number 2 is.
They have only given number 2. Number 1 they have not given.
No, we have.
If your Lordship
skipped that
kindly
order.
see this. They should have to comply that direction.
No, I think, have you gone through the order, our order?
Yes, yes, I have given the order copy also.
The order we have stated that it is.
Yes, yes, last paragraph.
We have
In the order,
specifically
last
stated.
paragraph is there.
Yes, Mr. Nataraj Learning Swanso and Mr. Acharya on instruction have fairly submitted.
Yes.
That in so far as the demand number 1 and 2 are concerned, the same would be accepted as it is. Yes, of
And
course.
this is the affidavit. Paragraph 4, 5, 6.
One टा कौन थी लगी expeditious and timely. One टा कौन था उधर देखिए.
Paragraph 4 is important.
Expeditious and timely completion of work.
The 10A 1, 2.
तू ठीक अछि आपण कहउछन one टा देइना दिना कोन टा देइना
1 टा देना 2 टा देई देन
is concerned, it is submitted that out of all the persons in terms of the list presented to the affidavit at paragraph number 21, only 25 are stated to be not granted the alternative, who will be provided with alternative work within a period of 1 month. Achi to 2 ta hela pura.
No sir, 2 टा देइछंती. 1 टा expeditious timely completion of the work at the resettlement site as per the approved plan, preferably within a period of
6 months they'll do it.
6 months.
সেটা দিলেন affidavit.
এটা আছে they are silent about it.
এটা কোট করা হয়েছে.
They are silent about it.
Yes. এটা কোট করছেন to acknowledge this. The government is your MCL actually.
কোনটা omit করিও লাগি টেল.
এটা omit করে দিয়েছেন দেই না.
Then we have said that to that effect a detailed affidavit has been filed.
Yes.
କହିଲେ ନା କୋର୍ଟ ରେ କହିଲେ ଆମେ ଫାଇନ୍ କରିବୁ ବୋଲି.
Sir, that is exact because I don't have the occasion to again bring your also notice. They should file the affidavit related to 1 also. So there is specific direction.
ଏଟା ଗୋଟେ କାମ କରନ୍ତୁ ଏଟା ଟୁ ବି ମେନସନ୍ ନେଇ ଆସନ୍ତୁ କହିଦେବେ ଆମେ ଆପଣ କପି ଗୋଟେ ଦେଲେ ନା
ସେ ଜାଣି ତାଙ୍କ ପାଖେ ଅଛି sir.
ଏଇ ନମ୍ବର 1 ଟା
No,
ପାଇଁ ଆମେ
you have to write a letter that you have mentioned. Therefore, this matter is being listed to in the to be mentioned. He has to write a letter that today you have mentioned the matter.
Yes.
And matter is now listed day after tomorrow.
Yes, I'll inform.
You in writing you must give.
Counsel, yes.
just give it by
To be mentioned.
mention ଗୋଟେ memo file କରି ଦିଅନ୍ତୁ
Sir, ଆଜି କରି ଦେବି.
Yes.
I'll remember.
Write a letter to the Advocate General as well as
ତାଙ୍କ ଦରକାର ନାହିଁ MCL counsel.
Counsel.
Mr. Rakesh Sharma has filed the affidavit.
ଆପଣ ଏଇଟା ତାହେଲେ ରଖିଥାନ୍ତୁ.
Sir.
ଏଟା କାହିଁକି ଆମେ ଇଏ କରି ଆମେ
ନାଇଁ sir,
ଦେଖିଦେବୁ.
file କରିଦେବୁ.
But just communicate to the Learned Advocate General.
କପି ଦେଲେ
ତାଙ୍କୁ ଗୋଟେ ବି ଦେଇ ଦିଅନ୍ତୁ. କାରଣ ଆମେ order already ଲେଖି ସାରିଲୁଣି ଯେ
affidavit has been filed.
Affidavit has been filed. Open court ରେ କୁହାଲା ନା.
ଏଇ କପି. ଆଚ୍ଛା.
Then subsequently they have filed the affidavit.
ଆମେ ଡାକିଦେଲୁ ଡିକ୍ଟେସନ ଦେଇଦେଲୁ ତାପରେ ଆମେ ଭାବିଲୁ ସେ order ଲେଖିଛୁ
Day after tomorrow.
Let's make in item 47. There is a request of the Honorable Supreme Court to take up this matter, and therefore your Lordship listen to the matter today.
The Supreme Court said in lunchtime.
I mentioned it, and your Lordship, please keep it today. Item 47. I frame last day after tomorrow. If your Lordship
final disposal matter is list body ଚାଲିଛି.
This is a PIL matter which came before my lord the Honorable Chief Justice who recused him. It has been directed to be listed before your Lordship. Because there's it's a very short point involved.
Time bound direction.
Yes, sir.
orders नहीं है
If on now it came up, your lordships were of the view that since it is pending for the Supreme Court, so your lordship didn't take it up. But the Honorable Supreme Court has now made it clear that your lordship may kindly proceed in the next page. However, the earlier order passed by this court made it clear that the pendency of the SLP would not come in the way of the High Court in deciding the interim applications or the writ petition. In light of the aforesaid order, we request the High Court to hear the writ petition and or application further presently pending consideration on merits and in accordance with law instead of awaiting the result of the present SLPs. The counsel appearing for the respondents fairly states that they would not be seeking an adjournment before the High Court on the next date of hearing, that is 18-8. 18-8, for some reason.
There is no direction there says to.
Yes, but it says, earlier when it came up, Malats were of the view that since it is pending before the Supreme Court, so therefore.
Where is the direction to the, where is the request made by the Supreme Court to this court that it should be disposed of within such.
No, there is no time bound direction, but there is an interim order and also there is a stay vacation. This is urgent.
May I pardon to mention, my lord, item 40 on behalf of Mr. Ponda, my lord. Item 40 on behalf of Mr. Ponda. There is an interim application to attend the first death anniversary of the wife. IA is also there. May I pray your last item?
It was directed to the State Council to obtain instruction.
Yes, my lord. That is order written 9.
Item number?
Item number 40, your lord.
40.
All right, yes.
We plan to mention lordships. Criminal appeal I have filed a IA for interim bail. We taken out tomorrow. We have to.
Criminal appeal file for IA for bail.
One mention, which lordships time permission. I think in item 6, your lordships were pleased to appoint me as an amicus curiae to conduct the case. Now I find the accused has sent a petition saying that Sri S.S Mishra to conduct the case on his behalf. So as your lordship is, I am ready to assist, but it's the petition that has come. And Mr. S.S Mishra had talked to me. You are saying that he has received the instruction. So it is a privilege for me that your lordship was pleased to direct that I should assist your lordship.
All right.
But in view of this position, as your lordship is.
All right. Prisoner item number 6 for the Though a prisoner's petition has been received for engagement of Mr. S.S Mishra, but since we have already engaged Mr. Samit Kumar Mishra and senior advocates as the amicus curiae for the appellant, Mr. Satyanarayan Mishra shall now assist Mr. Mishra for arguing this appeal. That's all.
One more prayer is, the paperwork I was requesting.
Let a copy of the paperwork be immediately handed over to the land senior advocate. Just send one of your associates will.
And this will be taken up next week.
Yes.
And there may
I do not know why it has come for as a bail by SG. Who has filed the
I am Madam. Bail task, return bail. The Metro job 2015, Madam.
We'll see that too. You have filed the application.
Yes, and I have also received the paperwork.
So get ready for, you'll see that when the matter reaches civil, you will see.
Yes.
But for hearing, we have said that you assist Mr. Mishra here. All the matter.
Weekly list item number 1.
Wait, Vijay also. Since I have not received the paperwork. However, they have filed it to miscases.
It has not been admitted.
Not been admitted.
Admitting any.
Yes, also, sir.
There is no formal order of admission.
Yes, also. But the paperwork has been ready.
You preempted that order.
Listen, how I admit call for the trial court stop. Trial court record has already been received, so also the paperwork has been prepared. Get a copy of the paperwork be handed over to Mr. Das and counsel for the applicant. You have received the copy. The counsel submits that he has received the paperwork.
I have filed one bail application and one.
It is not there on record.
There is no.
That is not in record.
No. Can you tell the number of the interim application?
Your Lordship, today I have filed.
Mr. Das submits that he has filed 2 interim applications. One for bail and the other for stay relation of.
Yes,
copies have been solved.
No, madam.
Let the copies of the interim application be solved on the land council for the state. Matter be placed in review commencing from 22nd September 2025 for orders. The interim application be placed on records. Yes. How many years he is in custody?
Since 2017.
The land council for the state shall obtain the custody certificate. So also take instruction regarding the criminal antecedent, if any, against the petitioner. So also his conduct in charge is jail. Yes.
Item number 2.
Appearing on behalf of Mr. Lord, I have filed the IA for correction of for title. He wrongly mentioned under article, my lord. May I allow you? But my lord.
No, what is this appeal for? Appeal for my file to 10 years.
Total adjustment.
What? Total.
Appeal against total.
He faced trial under 302.
302.
Who is this Akshay Kumar Panda? Is the informant?
Yes.
IA number 2191 of 2025 is an application for correction of clause title. The land counsel for the petitioner submits that inadvertently in the clause title has been mentioned as 370, Article 378(4), read with 372 of CRPC instead of 378(4), read with 372 provisos CRPC and read with 419 and 415 of BNSS 2023. And therefore, the same will be permitted to be corrected. Land council, after hearing the land council for the state has no objection. Accordingly, the interim, pre-having the interim application is allowed. The land council for the applicant shall file a fresh cost title.
Consolidated cost title.
Consolidated cost title. Within a week, giving a copy to the land council for this one. Yes. Thereafter, the matter shall be placed for admission, and in the meantime, the land council for the state shall obtain instruction whether the state is intending to prefer any appeal challenging the order of acquittal passed by the land trial board. Yes.
Item 3.
My lord, I have received the paperwork on behalf of the spoke on this, my lord. I am not ready, I paid for 1
Yes?
I am not ready, I paid for 1 week time.
You are in both the matters you are there.
Both the matters I consider. In the second item, the appellant has released on bail, my lord.
No, it's all right, but today it has come for consideration of that phrase admission is there. It is a conviction matter.
Conviction matter, my lord.
So
Conviction-
by seeking for adjournment, it is to be admitted.
Yes, my lord. It is admitted.
It's a 302 case.
302, my lord.
Oh,
Last time delay was condoned.
देखो CRLA number 980 of 2025. Order me. Sati को छड़ देंगे. तापर लेखों तो पूरा आई अच्छी sterilization of fines से रवा लगते हैं. बाकी उड़ा आई अच्छी for bail land counsel for the appellant 6 for an adjournment. I put up this matter on such and such date for orders. This matter should be listed along with CRL number 112 of 2022. Land counsel for the appellant submit that he has received the copy of the paperwork. Land counsel for the state also submit that he has received the copy of the paperwork. Yes, next.
Item 4.
Counsel for life policy.
Offense
302 of Indian Penal Code.
302. That admit for the trial court report, interim application transfer considered after receipt of the trial. The petition copy to be supplied to the land counsel. Yes.
Item 5.
No, due to lots of error, a noting shows that surrender report not received. This is a jail criminal appeal. Your lordship may direct the concerned learned ADJ to produce the same because we don't have contact.
Sunita Biswal and counsel for the appellant is present and submits that she has no instruction whether the interim bail. As per order dated 5/5/2025, the appellant has surrendered in the trial court or not. In view of such submission, the file be placed before the land and register judicial. He sent an email to the concerned trial court to obtain a report as to in that respect of this matter. Yes.
Item 6.
No, bail payment.
Bail that's my friend.
Yes.
May I please, your lordship, madam?
How many years you are in custody?
I'm in custody since 5/4/2010.
5/4/2010.
2010.
Where is the custody certificate? Have you got the custody?
Then the custody has been returned.
IA number such and such. This is an application for bail. फिर आगुन उठे order रखा है था ताकि लिखी देगा. The land counsel for the appellant submits that Mr. Mishra for them. Land counsel S.S Mishra for them. Land counsel submits that he has the appellant is in judicial custody for since 2010.
Yes, 5/4/2010.
5/4/2010. Land counsel for the state 6 sometime to produce the custody certificate, criminal antecedent or jail conduct. Yes.
May I request one thing, madam?
Yes, next.
So that S.S Mishra form is.
It's a 4 in
Yes.
in the clause list. The name of Mr. S.S Mishra be reflected as S.S Mishra -4.
Obliged.
Will please also directly to provide a copy of the paperwork.
Paperwork
That we have seen.
that will.
Obliged.
Item 7.
If I may please your lordship, my lord. My lord, there is a prisoner petition.
Prisoner's petition at flag K for engagement of Milan Kanungo in place of previous counsel S. Saurabh. No Karatnama has been filed. To appearance memo,
Lord,
Oh, you are Mr. Saurav.
Your Lordship.
Acha, item, appellant number.
And that is appellant number 1, Jagdish Kisan. For appellant number
Prisoner's petition कहाँ पाई अच्छी?
for Jagdish Kisan, appellant number 1.
So 2 पाई तो अपन continue करेंगे. There are 2 appellants.
Your Lordship. Basically, there are 4 appellants and 3 appeals.
No, the issue of a particular appeal.
Particularly these are options.
Your
Lordship.
Kanungo should give consent.
No, this it has come for only appellant number 1, so he will continue for at A2. But Mr. Milan Kanungo has not associated.
Milan will knowing also.
Now also to miss for the you just inform Mr. Kanungo about it.
Intimate copy. An intimate Lordship.
The prisoner's petition has been received from appellant number 2, na?
Jagdish Kisan is 1.
Achha, appellant number 1, Jagdish Kisan, for engagement of Mr. Milan Kanungo, senior advocate, in case of Mr. S. Saurav. Mr. S. Saurav, appellant counsel, is present, and he submits that he will continue as the advocate for appellant number 2, and will also engage. They also instruct Mr. Also communicate to the land senior advocate, Mr. Milan Kanungo, about the prisoner's petition. Put up this matter.
But I have a bail application of appellant number 2 pending.
Which one?
Appellant number 2, Your Lordship.
The 131.
Your Lordship.
So, is it rejected earlier?
Yes, my lord. It has been rejected once by 10/1/2022's order, 10/1/2023's order.
Now, how many years you are in custody?
My lord, for more than 12 years, Your Lordship, I was taken into custody on.
Any custody certificate available with you?
I don't have it, Your Lordship.
Get it? IN number 131 of 2023. This is an application for bail filed by appellant number 2. That is Ganesh Kishan, na?
Indeed, Your Lordship.
Ganesh Kishan. Mr. S. Saurav, Land Counsel, appearing for the appellant number 2, submits that the appellant number 2 is in judicial custody since
28 April 2013. 28/4/2013.
28/4/2013. You stop. Land Counsel for the state 6 on time to the custody certification here. So I have put up this matter. Yes, next.
When it is posting it to?
In the evening, you can see from. We'll upload the entire video.
Great.
Item 8.
May I please, Your Lordship? My Lord, there is a prisoner petition at flag C.
Single appellant?
Single appellant.
Period the prisoner's petition at flag C regarding engagement of Mr. Soumyaranjan Das in place of Mr. B.C. Parija, Vikas Chandra Parija. You have filed your Vinama. Mr. Das has already filed the Vinama. The name of Mr. Vikas Ranjan. SK Dwivedi is your advocate, your associate. The name of Mr. Vikas Chandra Parija shall not be reflected in the cause list henceforth. Yes, what about the stay, bail and stay?
My lord, with 2 IA filed, first KF fine and for bail.
302 case.
302 case. He is in custody around 15 years, 6 months.
Achhi custody sir?
Yeah, my lord.
Agu rejected like?
No.
Single murder?
My lord. Of his own son, my lord.
9 years?
9 years.
Eyewitnesses are there?
Eyewitness came out. Only case response circumstantial.
Last scene ochi recovery of dead body ochi motive. Last scene theory ochi recovery of section 27 recovery ochi weapon of.
How the murder was committed?
My lord, when the appellant father and mother had gone to attend a marriage ceremony, the appellant and the deceased were all alone in the house. When they returned from the marriage ceremony, they found the door locked. They searched for their daughter and grandson and found her daughter near a bus stand, who told her that I have sent my child to her husband's house.
No, the petitioner is the father of the deceased.
Mother of the deceased.
Mother of the deceased.
Oh, mother of the
My
lady.
lady.
Oh. Why he killed his son?
My lord, so far as PW 1, 2, 3 have been examined, they have stated that she is in a mental trauma.
No, she is not a mental.
She is mentally unstable, my lord.
सी जहाको बाहा इला तार हस्बैंड सी मेंटली अनस्टेबल थिला यार राग थिला जे मते अनस्टेबल लोक को काई बाहा कर दैट वाज द मोटिव से टाइम एंड अगेन धमकी दोतला जे मु समस्त को मार दे बोली
But it was his own, her own son, no?
Own son.
So the marriage must have taken place about 10 years back because the child was 9 years. So
it happened in 2002. She
I
got married
thought
in
it was his
2002.
her stepson, but it was her own son.
You will kindly see PW 11 for a moment. That is the PM doctor. Kindly see the manner in which it has been.
PW 11.
PW 11.
With some hard weapon, it was.
Wooden baton re marriage. Number of injuries.
देखिए custody certificate है.
Paragraph 3 रे से wooden baton टा confront भी ହେଇଛି doctor.
15 years, 6 months.
15 years.
Wow. Jail criminal appeal 77 of stay relation of crime that was the IA number so and so. The land counsel for the petitioner has produced the custody certificate issued by Chief Matron Nari Bandi Niketan, Sambalpur. It shows that the petitioner is in judicial custody for more than 15 years, 6 months. The custody certificate is taken on record. Then counsel for the petitioner submits that the case of the prosecution is that the petitioner killed her own son and that there are no eyewitnesses to the occurrence. And in view of the period of detention in judicial custody, the bail application may be favorably considered. Land counsel for the state will not disputing that the case is based on circumstantial evidence, based the evidence of the doctor back at the PW 11 who conducted post-mortem examination over the dead body of the son of the petitioner who was aged about 9 years and noticed number of lacerated wound as well as incised wound and to find that the cause of death was due to head injury following blunt trauma. Considering the submission made by the land counsel for the respective parties, the period of detention of the petitioner in judicial custody, and since this is a good lady, we are inclined to release the petitioner on bail. Yes. No.
Item number 9.
What is your good name?
Araj Naik.
So and so. अच्छा ଗୋଟେ prisoners petition ଆସିଛି ଅଜୟ କୁମାର ମହାରଣାଙ୍କ ନାଁ.
He is the junior of the S.S Mishra.
Mention is made by so and so on behalf of Mr. R.C. Maharana for adjournment. Place this matter on such and such date with CRA number 567 of 2020. Yes, not.
Item 10.
May I please your lordship, madam? Custody since 24/5/2016, my lord.
20?
24.
Custody certificate.
No.
Have you got custody? Mr. Mishra and Counsel for the appellant submits that the IA number for petition application for that the appellant is in judicial custody since
24/5/2016.
24/5
Yes, same day I filed.
24/5/2016 2016. And counsel for the state hours 6 some time to produce the custody certificate, but the criminal antecedents so on so on.
And the same request, my lord. Like S.S Mishra for me.
The name of the land and council we mentioned in the cause list as S.S Mishra 4. And Satyanarayan Mishra 4-4.
And maybe permitted to take the teaser in interim, my lord. Sir, subcopy of teaser.
Position copy nahi?
Yes, the person.
Then you will be given the paperwork is ready. So what if more you want? You have received the copy of the paper.
Yes.
Then for bail matter, what more you want? Yes. Next.
11.
Discuss one other petitioner custody in more than 9 years ago.
Minor prayer for bail, item number 24, 2024. The number of registration, informant.
There should be an item number 30. The informant and the victim has received the notice and they're inclined to go for the High Court legal aid something. They have submitted, they have forwarded the Vakalata, which is yet to be.
Correct. As made the land council for the state is Subalakshmi Devi submits that the informant are interested to oppose the bail application by engaging counsel through High Court legal aid committee. And Wakalatnama has already been sent. That the High Court Secretary, High Court Legal Aid Committee engage a counsel for the informant, and the matter be placed on such and such date. The copy of the judgment along with the prisoner's petition, so also the copies of the interim applications filed by the land council for the appellant be served on the land council for the informant.
Maya, क्वेश्चन से फिर
इन्फॉर्मेंट जो काउंसिल को एंगेज करिवे हाई कोर्ट लीगल कमिटी आपण जजमेंट कॉपीटे और जो दीटा इंटरिम एप्लिकेशन फाइल करछंती से तार कॉपी से इन्फॉर्मेंट काउंसिल को दे देबे तो कहा को एंगेज करिवे हमें तो जानिनु सेक्रेटरी हाई कोर्ट लीगल सर्विसेज अथॉरिटी करिवे तांकर ना आसीबो बुझी देगिन तां दे देबे से ऑलरेडी वकालतनामा पठेई देछि
नहीं
बेल अपोज करिया पाई यस नेक्स्ट
14.
14, my lord, there is a prisoner petition, my lord, at flag D, Deep Mahanti. My lord, tomorrow, my lord, I will file the Vakalatnama.
You are Mr. Mahanti.
Yes, my lord.
Prisoner's petition has been received regarding engagement of Mr. Kuldeep Mahanti in place of Mr. Ashok Kumar Saran. Mr. Kuldeep Mahanti and counsel is present in court and submit that. Gottakali file kale?
Tomorrow, Kori.
Acha. And submit that he will file the Vakalatnama tomorrow. Stop. Put up this matter on such and such date. Put a Sakra Pragabhyanda.
My lord,
Have you filed any interim application?
no, my lord, I don't have any paper, my lord.
In due course. Huh?
I don't have any paper, my lord. No. Paper book may be, my lord, provided.
Acha. You file the Vakalatnama, then you will be. The moment Mr. Mahanti files the Vakalatnama, the copy of the paper book shall be supplied to him.
And my lord, one more thing, my lord, custody period may be called for, my lord.
No, you are not filing any interim application by custody period only. You file, if you want to file any application for bail, file it. It will be listed and they will ask.
My lord.
Yes.
Item 15.
Acha, the name of Mr. Ashok Kumar Sarangi and his associates shall not be reflected in the cost list and disposal. Yes. Yes, Mr. Panda.
What?
Oh, you are there. Prisoner's petition has been received for engagement of advocate D. Marandi in place of S.R. Pati at flag C, filed without taking. How many appellants are there?
Only one.
Then why he has
Like
Mr. Who is Mr. Marandi? Acha. So Mr. Das will appear along with you. Okay. Pay you the prisoner's petition received for engagement of D. Marandi in place of Mr. S.R. Pati. You have filed Vakalatnama.
yes, I'll put this.
Acha. Vakalatnama has already been filed by Mrs. D. Marandi, which is on record. So the name of the Mr. S.R. Pati. S.R. Pati on Nada Chi. S.R. Pati and his associate shall not be reflected in the cause list henceforth. Yes, what about bail?
Lord, there is a flap lot. IA 964.
No, that is all right. How much period you are in?
Lord, 2007 season custody.
What is that custody certificate?
Custody certificate.
Are you having any? Acha, Mr. Das and counsel, IA number so and so is an application for bail. Mr. Das submits that the petitioner
Arrested
is in judicial custody since
1/5/2007.
1/5/2007. State counsel took some time to produce the custody certificate from a criminal antecedent and also EGL conduct to put this matter on such something. Yes.
Item 16.
Council had order dated 28/8/2025 that wish to direct to obtain instruction that at the time of interim bail period, whether the present petitioner violated any conditions, the conduct of the petitioner filed on interim bail.
One. He has report.
The back side.
Prematurely লেখা হয়নি এটা নয় ভুল লেখা
সেকেন্ডটা ভুলে ট্যাগ করে দিয়েছি সেকেন্ডটা অদার কেসে এটা ভুলে ট্যাগ করতে
এটা নিয়ে
other first page is back side. First page रे back side is report. Second page ता wrongly tag कर दे.
What about his conduct outside? You have given the conduct inside the jail. During the period of confinement in sub-jail Parala community, his behavior conduct was good. It's satisfactory. We don't want that. We want that when he had on outside, what was his conduct? Whether he had
some time in
local, you have to get it from
local police station. It was not the the learning council for the state has produced the written instruction received from such and such date, which shows about the conduct of the petitioner inside the jail. However, this court has asked the land council for the state to obtain instruction regarding the conduct of the petitioner while on interim bail, which was to be obtained from the inspector in charge of Arudegiri, na?
Yes,
Arudegiri police station. Land council for the state seeks some more time to obtain instruction in that respect. Put up this matter answer. Yes.
You know, I pray if possible before vacation.
No, आज evening रे देखी थी बड़ा सब आसी हो. Yes, next.
17.
Heading for the island number also these are application for bail rate and Mr. Sahoo is present for this. Yes. Item 17.
Your lordship directed for custody certificate. And in the meantime, one of the co-appellant also released on bail in another hearing.
In the lordship, there is a confusion of this judgment, interim judgment. If judgment making there it is means Rayagada PS case 1 of 2000.
Rayagada. Rayagada that is under Paralakham, that is under Godpati district.
No, Rayagada is
that is a separate district, but Rayagada police station also in Godpati.
But they are intimating today over the PS case is 1 up to 14 relating to other person, not this person. So we may some time.
No, Rayagada, that is Rayagada.
No, the PS case is. You saw the trial protector of the trial. FIR to Vasili. I thought the
Rayagada PS case.
2014.
And today I have contacted the Rayagada PS.
Lima Sabar.
Lima Sabar ଅତି ଅଛି. So ସେ ବେଳେ ବେଳେ ଗୋଟେ case transfer ହେଇକି ଅନ୍ୟ court କୁ ପଳେଇ ଯାଏ.
ମାନେ ଯୋଉ 1 of 2014 they have sent from registration stands in the name of other person.
No, अरे भाई ଏଇଠି ଅଛି ପରା.
FIR. I have sent it. The cost title front page I have also again sent to him.
No, you send the copy of the FIR. Exhibit ହେଇଛି. Exhibit ହେଇଛି ଏଟା ରାୟଗଡା ଏଟା ପ୍ଲେସ୍ ହେଇଛି ପାରଳାଖେମୁଣ୍ଡି SDGM ଙ୍କ ପାଖରେ ଉପରେ ସିଗ୍ନେଚର ଅଛି SDGM ପାରଳାଖେମୁଣ୍ଡି 4/1/2014 ରେ ପ୍ଲେସ୍ ହେଇଛି. Then the trial was conducted in the court of additional session judge ପାରଳାଖେମୁଣ୍ଡି. ଆଜି କଣ ଅସୁବିଧା କଣ ହଉଛି?
Say Rayagada, IAC Rayagada intimate that say 1 of 2014.
Maybe what he says is this is another Rayagada in
Rayagada in Gajapati district.
It is a village.
You may telephone Rayagada in.
It is not Rayagada as such. The big town. It is another place.
Some time in Valot.
In Gajapati district there is another Rayagada.
That is near Mohan.
ଓ ଆପଣ ରାୟଗଡା ଡିଷ୍ଟ୍ରିକ୍ଟ ରୁ ମଗେଇଦେଲେ କି?
ଟାଉନ ରୁ ମଗେଇ ଦେଇଛି.
IAC Rayagada.
ଏଇଟା ଗଜପତି ଯୋଉ ପାରଳାଖେମୁଣ୍ଡି ସେଠି ଗୋଟେ ରାୟଗଡା ପୋଲିସ ଷ୍ଟେସନ.
That is in Odia Rayagada.
ଆଚ୍ଛା The learning counsel for the state submits that he may be given some further time to obtain instruction in terms of the
One of the co-appellant released on bail, my lord, can I produce? Okay.
In terms of the order dated 21/7/2025, allows the miss case number 1008 of 2015 ता दे लिखिए है ना in terms of the order dated 21/7/2025 put of this matter चेटा उड़ दे yes
Short date, my lord.
हाँ से सब देख इवनिंग रे देखी लोगे
हाँ.
next
18.
May I please, Your Lordship? My Lordship, by the order dated 21/7/2025, Lordship had directed the state to take instruction about the conduct of the appellant during interim bail millers. And the time was allowed on 28 millers. Last two orders millers, time was
okay,
allowed.
the land council for the state seeks some more time to obtain instruction regarding the conduct of the petition while on interim bail the number to the bail application put up this matter on such answers date as a state relation of find out allow with them. S.S Mishra R.R. land council for the appellant. So fine state बाकी पैसा को अर्जन पर भी दो टू हो
Maybe this side of the elders, my lord.
इवनिंग रे देखी दे पूरा पहुंचू जे केबल दे फिक्स हो
19.
Mr. Vishwaranjan Swine, Akash Bhuiya. Yeah.
Last week we call for the custody period.
Custody certificate.
नयागढ़ जो बैंक की पीरियड ट्रांसफर जाता है
कौन है जी
सर नयागढ़ तो बैंक की पड़े थे नयागढ़ वाज प्रिविलेज फॉर सच पीरियड्स द बैंक हैज
अभी रोटे दी थी लेगी
हां नयागढ़
नयागढ़ देखू छी
28 to 2017 to 11 to 2018, Nayagarh jail. Thereafter Banki. From 11 to 2018 onwards.
टोटल पीरियड है 10 वर्ष 5 मास 19 दिन टोटल पीरियड है
टोटल कितने हला
10 वर्ष 5 मास 19 दिन
28 to 2017.
एटा होची आपनकर हां 10 वर्ष दीटा को मिसई दी जन
सब मिसई जन
अच्छा सब
29 दिन 11 प्राइस है पीरियड वाइज है कैलकुलेट
वो जेल में मध्य लिख दी जन हां सब जेल सोंस मायागढ़ ठीक है तो 10 वर्ष आगुर बेल रिजेक्ट ही था
Yes, 2 times rejected.
हां
2 times
Twice.
rejected.
के लास्ट टाइम के रिजेक्ट ही
10 11 1 21
302 case
Yes, sir. So
single murder
Yes, so like this. No, I think.
Are the land council for the petition land council for the state. The land council for the state has produced the custody certificate of the petitioner which shows that the petitioner is in judicial custody for more than 10 years. The same is taken on record. The land council for the appellant submits that the bail application of the petitioner was rejected on merit on 11/1/2021. However, since there is no chance of early hearing of the appeal in near future, keeping in view the period of detention in judicial custody, so also the ratio let down in the case of Letty versus states, the bail application may be favorably considered and accounting for the state application if they had for the cinemas bail they did. Yes.
3 months
3 months.
Item 20.
Item 20, Mr. Sahoo.
May I please? We go to case number of 26/27.
the deposition copy is required.
Dina di? ବେଲ୍ ପିଟିସନ କପିଟା ଦିଅନ୍ତୁ। ଆଉ ଆଣିଛନ୍ତି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ କେତେ ବର୍ଷ ହେଲାଣି? କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଅଛି ଆପଣଙ୍କ ପାଖରେ ନା ମଗେଇବେ? ହଉ ଲେଖନ୍ତୁ miss case number so and so, this is an application for bail. Let a copy of the miss case be served on the land counsel for the
This
state.
case along with the evidence. Deposition.
Criminal appeal. Deposition copy ଅଛି ଆପଣଙ୍କ ପାଖରେ? The deposition copy shall also be supplied to the land counsel for the state. Stop. The land counsel for the petitioner submits that the petitioner is in judicial custody for more than 12 years.
27/8
ठीक है जी।
2014.
The land counsel for the state seeks some time to produce the custody certificate as well as to obtain instruction regarding criminal and prevent of jail conduct. है ना? Put up this matter on such and such day. मिस केस रो जो बेल रो कॉपी टे दियंतु और डिपोजिशन कॉपी स्टेट काउंसिल को देन है ना?
मिस केस को भी दिया है।
वो ता पर नाही जो आउट कॉपी कोन जेरोक्स कर देले कर दियो। यस।
Item number 21.
The number 5/2/25 for payment. After interim bail, order dated 9/25. Conduct.
एटा होची अपरेंट नंबर 3 और 4 पे दीजन।
My lord.
आगुर जाइथिले बेल।
My lord.
को ऑर्डर दीजन जा जाई।
Order dated
The report they change, but they are inside the jail. But after से period टा post release interim bail period टा देना।
कंडक्ट माने अपन जो बाहर गले एक करबे सम आ भीतर थिला बळे दैट इज डिफरेंट। अच्छा केबे जाइथिले 3-4
जेती my lord. Find the आगे my lord.
बट अच्छा हां जाइछन 3 टा अलगा डेट रे जाइछि 4 अलगा डेट रे जा जणा पड़छि 4 जाइछि 5/8/2024 है 4 5 8 2024 3 ता पूर्व जाइतला हम्म 23/7/2024 देखो the IA number 76 IA number 542 of 2025. This is an application for bail filed by appellant number 3 and 4. It seems that the appellant number 3 was directed to be released on interim bail for a period of 3 months as per order dated 23/7/2024. And appellant number 4 was directed to be released on interim bail for a period of 3 months as per order dated 5/8/2023. Stop. The land counsel for the state seeks some further time to obtain instruction as per the order dated 9/4/2025. And 28/7/2025. Of this matter on such and such. Yes.
Item number 22.
Yes, Mr. Sahoo.
Kumar Mishra. There is a prisoner's petition to imbue Mr. Mishra.
Sorry? Speak little louder.
कौन कहउछंदी?
Lordship, I am on behalf of Mr. Dilip Kumar Mishra. There is a prisoner's petition to imbue.
Yes. Have you filed your Vinama?
Yes, ma'am.
Prisoner's petition has been received for engagement of Mr. Dilip Mishra in face of Mr. Deepak Kumar Sahu. Wakalatnama has already been filed by Mr. Mishra. Let the name of Mr. Dilip Kumar Sahu, the name of Mr. Deepak Kumar Sahu shall not be reflected in the cause list henceforth. Stop. Baki aur kaun?
I also we permitted to collect the copies of the memorandum of appeal, IA and deposition, the soft copy.
The land counsel for the appellant submit that he may be permitted to take the appeal memo, copy of the impugned judgment
Appeal memo impugned judgment IA copy or deposition.
Acha, copy of the appeal memo. So also the copies of the interim applications filed for bail and stay realization of fine in his pen drive.
And deposition. Deposition copy.
So also the deposition copies. Let the registry supply the same to the land counsel for the appellant. Yes.
Number 23.
On such and subject for consideration of the interim application for bail and stay realization of fine. Yes.
May I please? Just last occasion state to obtain the posture character and sorry. Last occasion state to obtain the conduct certificate of the prisoner.
Conduct and a custody certificate.
Fine to stay he.
Yes, ma'am.
खाली बेल पे है
I
IA number 1140
And this is a case of triple murder, sir. The mother killed his.
बेल आगु रिजेक्ट ही
No.
केते वर्ष आपण ହେଇଛନ୍ତି
Custody matter
11/9/2016.
7 years 8 months.
8 months. Triple murder
in the case the person is the mother and this is the child.
ସମସ୍ତେ କୁଅର ପକେଇଥିଲା ନିଜେ ବି କୁଅର ପଡିଥିଲା ତାକୁ ଅଦର ରେସ୍କ୍ୟୁ.
No, my lord, the informant to commit suicide, Lord and PP.
Try to commit suicide. He was rescued and immediately she fled away from the house.
What is his mental condition now?
That was directly issued.
Actually, my lord, the informant is the hostile. Lord and PP declare hostile.
Informant ଆପଣ ଯୋଉ ଟାଇପ ର ଇଏ ଆସୁଛି ଜେଲରେ କିଛି ଗଣ୍ଡଗୋଳ କରିନାହାନ୍ତି ବୋଲି ଆସୁଛି ରିପୋର୍ଟ କିନ୍ତୁ ଏଇ ଯୋଉ ଯାହା ଫ୍ୟାକ୍ଚୁଆଲ ସିନେରିଓ କହୁଛି ଆପଣଙ୍କର 3ଟା ଛୁଆକୁ ଆପଣ ପୁଅ ଭିତରେ ପକେଇଦେଲେ ନିଜେ ବି ଡେଇଁ ପଡିଲେ ଆପଣଙ୍କର ମେଣ୍ଟାଲ କଣ୍ଡିସନ ର
There was quarrel between the appellant and her husband. Quarrel, there are dispute between the appellant and husband.
ଛୁଆକୁ ଧରି ଡେଇଁ ପଇଲା ଆଉ କଣ
actually the PW 17 my lord page number 60-70 the merit
PW 17 rescued the appellant along with the help of one villager. PW 17 is a one she was staying in the house.
You and your 3 children came inside the well. What is your explanation?
Actually, my lord, there is a
actually no. What is your explanation in your accused statement? 3ଟା ଯାକ ଛୁଆ ଆଉ ଆପଣ କୁଅ ଭିତରେ କେମିତି ପଡିଲେ?
Actually, my lord, there is an open well which is the court in the courtyard.
ଆପଣ କ୍ଲିନ୍ ହେଲେନି ଓପନ ୱେଲ୍ ମୁଁ ଦେଖି ଜାଣି ପାଇଲିନି 3ଟା ଛୁଆକୁ ନେଇକି ଯାଉଥିଲି ଗଳି ପଇଲି ସେମିତି ତ କହିନାହାନ୍ତି.
Actually, PW 17 also stated.
ସବୁ ତ ମୁଁ ଜାଣିନି ମିଛ କେସ୍ ଆଉ
PW 17
ଆପଣଙ୍କର 3ଟା ଛୁଆଙ୍କର ଡେଡ୍ ବଡି ପୁଅ ଭିତରୁ ମିଳିଲା ନା ନାହିଁ?
Yes, ma'am.
ଆପଣ ନିଜେ ପୁଅ ଭିତରେ ପଡିଥିଲେ ଉଦ୍ଧାର କରାଗଲା ନା ନାହିଁ?
ପିଲାମାନେ ସବୁ ଖେଳୁଥିଲେ ଇନଫାଣ୍ଟ ଚାଇଲ୍ଡ ଛୋଟ ଶିଶୁ
ସେୟା ନେଲେନି ପିଲାମାନେ ଖେଳୁଥିଲେ ପଡିଗଲେ तापरे मु तांग बंचिया पई कुओं भितरु डेई पइली
My lord, she is also stated जे ମୁଁ ଏଇ ଜିନିଷ କରିନି କିଛି ପିଲାମାନେ ଖେଳୁଥିଲେ ମୁଁ ପଡିଗଲି ପିଲାମାନେ
ନାଇଁ।
ତେଣୁ ମୁଁ ତାଙ୍କୁ ରେସ୍କ୍ୟୁ କରିବାକୁ ପହଞ୍ଚିଲି ମୁଁ
313 statement କୋଉଠି କହିଲି
जो पेजटा कहउचंदी 313 को अनेक कोंतु अबिया मनगड़ा कहानी कहले किछि होबनी सेठी आपनको अपॉर्चुनिटी दिया गला प्रत्येक सर्कमस्टेंस आपनको पचरा जाइतिला एवं ता ऊपर कोन आपण
ତାପରେ ଗୋଟେ ଛୁଆ ହଉଛି 8 ମାସ
हम्म
ଗୋଟେ ଛୁଆ ହଉଛି 8 ମାସ ସେ ଯିବ କେମିତି
नहीं तार मेंटल कंडीशन आनंदी खाली वर्तमान व्यवहार ठीक पड़ची तार छुआ छोट छोट छुआ दी डेई पड़ती माने पुणी गले डेई डेई पड़ो जदी को जेल रे अछि ठीक ठाक अछि या
My lord, no witness actually PW 17
आई विटनेस
on the basis of
आई विटनेस लेकिन the land council for the state has produced the custody certificate of the petitioner which is taken on record. The land council for the petitioner submits that the petitioner was charged under section 302 of the Indian Penal Code as he threw his 3 minor children into the well and also jumped inside the well, and her 3 children died. However, the petitioner was rescued. Though he has obtained the report from the jail superintendent, but his mental condition is to be instruction relating to his mental condition is to be obtained and some more time be granted. The if necessary, the petitioner be produced before the psychiatrist, and the report of the psychiatrist we also placed on the next date. Put up this matter on Swanson. Yes, next.
Item 24.
May I please? Also is there, my lord, your lordship, last occasion directed.
ସେ
कौन है ला?
ସେ ନୋଟିସଟା ସର୍ଭ କରିଛନ୍ତି କରି ଭୋକଲାତନାମାଟାକୁ ଫଟୋ ଉଠେଇ ପଠେଇଛନ୍ତି ମୁଁ କହିଲି ଅରିଜିନାଲ ଭୋକଲାତନାମାଟାକୁ ପଠାନ୍ତୁ
Look, the land council for the state submits that though he has received the Xerox copy of the Wakalatnama, but he has instructed the inspector in charge of the Daspola police station to send the original Wakalatnama executed by the informant so that a counsel from the High Court Legal Services Authority committee can be engaged to oppose the application for bail. Put up this matter on such and such.
Deposition copy nahi, deposition copy nahi.
The land council, the registry shall supply the deposition copies of the trial court record पड़े ना सब अच्छा इधर पर regular appeal टा अपन दीजिए. The land council for the appellant shall supply the deposition copies of the witnesses to the land council for the state in the meantime. Yes, next.
Lordship, please.
संध्या वाले देखिए. Yeah.
Item 25.
May I please? Conduct certificate at flag D, my lord. They've gone on interim bail after expiry of interim and transferred with court now in custody. I have annexed the certificate at annex
और press bail file कर चंदी.
Yes, yes, please.
Conduct ऐसिला.
नहीं नहीं सेटलमेंट असला ये भी जो interim bail जाएंगे surrender कर that I have to.
नहीं conduct अपन. ये जो interim bail period का conduct है.
That instruction not.
नहीं है सुन. IN number 1 is an application for bail. Land council submits that the petitioner was directed to be released on interim bail for a period of 3 months as per order dated 23/4/2025. And after availing the same, he has surrendered at right time. The state council seeks for an adjournment to obtain instruction relating to the conduct of the petitioner while on interim bail. Put up this matter on such and such date. Adjourn next.
Item 26.
Yes, Mr. Chand. Manas Shah.
May please, your lord. Appellant is in custody since 28/6/2016.
First item na second item?
231, CRLA 231.
231 is first item. Who is appearing in the second item? Mr. Prashant Kumar Sahu.
In first item, petitioner filed a interim application, my lord. Yesterday, Mr. Chand furnished me copy. I forwarded to the IS but not received the instruction.
What is that interim application? On what ground?
Illness of wife.
সেটা আগুর মধ্যে সেই সিমিলার গ্রাউন্ড পেলে যাইଥିଲେ
Still bedridden.
ও নিয়ে আসুন ইনস্ট্রাকশন না নিয়ে আসুন IN number 1344 of 2025 এটা হচ্ছে প্রথম আইটেম থাকে CRL এ 221 না is an application for interim bail on the ground of ailment of wife of the petitioner, and land counsel for the state submits that he has received the copy of the interim application and seeks some time to obtain instruction. Put up this matter on such and such date. ঠিক আছে, the land counsel for the informant is present. বাকি তারপরে CRLA 178 madam.
Sub item 2.
কুহନ୍ତୁ।
For petitioner appellant age is 65 years and I am moving for on the basis of health ground of the petitioner appellant, my lord. He has been in the custody since 9 years 5 months.
Whether he has been released on bail at any point in time.
My lord, interim bail for 2 times.
Last time কেবে যাইছিলা?
On December 2024.
December.
21/24 রে
9/12/2024.
নিয়ে আসুন তার কন্ডাক্টটা নিয়ে আসুন লিখুন সেকেন্ড আইটেম লিখুন IN number so and so there is an application for bail. What is your good name, ma'am?
Premature, it's there in the cause list. Vaishak Mahanti. Vaishak Mahanti.
The time not even. So and so submits that the appellant was directed to be released on interim bail as for order dated 9/12/2024, and after availing the same, he surrendered at right time. State Counsel seeks some time to produce the inspection regarding the conduct of the petitioner while on interim bail. Put up this matter on such and such date along with CRLA number 231/2022. Yes.
Item 27.
Mr. Sahu. कौन ପାଇଁ ପୁରା ଖାଇଥିଲା? More time to comply order dated 14/7 ରେ କଣ ହେଇଥିଲା? 3 ମାସ ଯାଇଥିଲେ ସରେଣ୍ଡର କଲେ ଆସିଲା କି?
ଟିକେ nothing adverse.
କେତେ ବର୍ଷ ରହିଲା ପରେ ଯାଇଥିଲା ଆପଣ?
9 years.
10 years.
6 months. 6 months.
ଆଜ୍ଞା 2016 କୁହାଯାଇଛି ଆପଣ ପିଲା ବୋଲି 2016 ମାନେ 10 years ହେଇନି
9 years 3 months.
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ବି ଅଛି?
Yes.
ଦେଇଦିଅନ୍ତୁ
ଆଗରୁ କଷ୍ଟଡି ଅଛି।
ଆଗରୁ ଦେଇଥିଲେ?
7/6/25.
ଲାଗି
9 years. Nothing adverse was found against him.
My lord, I'll have to the postmortem report. Schedule 16 is the doctor.
Merit report ଆମେ ରିଜେକ୍ଟ କରିସାରିଛୁ ଆମ ମେରିଟ ରେ ରହୁଛୁ ନା କଣ? ସେ ଯୋଉ ଯାଇଥିଲା 3 ମାସ ଆଉ ଗଣ୍ଡଗୋଳ କିଛି କରିନି ସିଏ ସେଇଥିପାଇଁ ଫେରଲି ଯାଇଥିଲା କୋଉ ଅର୍ଡର ଡେଟେଡ? ଇଏ 6/12/2023. 6/12/2023 ତ ନା ତାପରେ ଆଉ ଯାଇଥିଲେ? The Learning Council for the state has produced the written instruction receipt from IIC Basudevpur Police Station, which shows that during interim bail period, nothing adverse was found against the petitioner. The report is taken on record. Stop. The custody certificate produced by the Land Council for the, এটা আপন প্রডিউস করতে না স্টেট কাউন্সিল প্রডিউস by the Land Council for the state. So dated 7/6/2025 indicates that the petitioner was in judicial custody for more than 9 years and 3 months. The Land Council for the state submits that the bail application of the petitioner was rejected on merit, however he was granted interim bail. Single murder, no?
Yes. Yes.
Wife
Wife was
husband.
killed by the by her
Petitioner
husband.
killed
14
his
number
wife.
of injury, 14 number of stabbing.
The Land Council for the petitioner state submit that on the bail application, the bail application has been rejected on merit. Considering the submission made by the Land Council for the respective parties, while not inclining to release the petitioner on bail on merit, but taking into account that the petitioner has not misutilized his liberty in any manner while on interim bail and he is in judicial custody for more than 9 years and 5 months per year. We are inclined to release him on interim bail for a period of 3 months. Yes.
Item 27.
28 no.
28.
27 dollar.
28.
Yes.
They verified the confession of co-accused.
Only my implication is just on the confession of the co-accused that yeah, lots of stated that the state will
4/8/11 of Allah.
What is the decision of the 5 judgments that on the basis of extra judicial confession or the confessional statement of co-accused, it is not a substantive piece of evidence, so cannot be utilized to convict an accused.
Urmi versus
74.
74
Supreme Court. Harish Charan Kurmi. Justice Rajendra Gadkar's decision.
10 ବର୍ଷ ହିଁ ଫରକ ପଡୁଛି 74 64
The IN number sworn, so this is an application for bail of appellant number 3. On the last date when the matter was taken up for consideration of the bail application, the Land Council for the appellant petitioner for the is an application for bail filed by appellant number 3, LD alias EP3, submitted that only material available against the petitioner is the confessional statement of co-accused, that is appellant number 1, Sultan alias Supadev Padi, report police, and except that there is no other material against the petitioner. Land Council for the state was asked to verify the records. Stop. Mr. Mahanti, Land Additional Standing Counsel, after verification of the record, fairly submits that except such a confessional statement of co-accused of appellant number 1, there is no other material against the petitioner. Considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody for
Lordship, only 5 years he is in custody, but the case is entirely based on the lady, my lord.
For
Because
5 years.
yes, since 2020, my lord, March.
And since she is a lady, and there is no chance of the hearing of the appeal. After hearing the land counsel for this one, so she also the informant. We are inclined to release the petitioner on bail allowed. Yes, ma'am.
Item 29.
Present, I have one, I
लिखिल पूरा
For correction of cost title, address already verified, only discrepancy is that जो अच्छी address तांकर West Singhbhum, that East Singhbhum, it was verified.
I will file the tomorrow in the CORAM.
आइएगा फाइल को जन पूरा
I will file for West Singhbhum को change करके East Singhbhum करा था. Only that part is wrong.
हाँ.
So I will file by tomorrow, madam, the corrected cost title.
Oh, you want correction of that one?
Yes. The fresh cost title I will file by tomorrow.
IA number 1850.
IA number 1850 of 2025. This is an application filed by the single appellant.
Yes.
By the appellant for correction of the name of the district in the cost title of the appeal memo. And counsel submits that the appellant belongs to district of Purabi bracketry East Singhbhum, but in the cost title it has been mentioned as West Singhbhum, and therefore she may be permitted to correct this error. And counsel for the state has obtained the instruction on the interim application and fairly submits that the petitioner belongs to East Singhbhum.
East Singhbhum. All other address correct, only district.
I mean, this is filed only for this appellant. कहाँ पे file करें? Gopal Yadav तो.
Yes.
This application has been filed by Gopal Yadav. That is appellant number.
Only the sole
Single appellant.
Yes.
Only appellant. ठीक है. Prayer is allowed. The land and counsel for the appellant shall file the corrected cost title within a week. अच्छा. By day after tomorrow, for example, the copy of the interim application for corrected cost title shall be handed over to the land counsel for the state. Matter will be listed on Friday. The
bail appeals.
For consideration, obviously. এটা হচ্ছে AI এটা ডিসপোজাল করা IN number 1850 যেটা কারেকশন অফ কস্ট টাইটেল না সেগুলোকে ডিসপোজাল করা আর বাকি এই যে শুক্রবার আসিব for consideration of the other interim application, that is for bail and CAD license. Yes. Yes.
Item 30.
No. I see order that 14th interim mail is granted for 3 months. Then surrender
14th May.
Yes, order number 4. Interim mail is granted
14th May থেকে কেনা 13th May दिया है 13th May order number 5 रे आपनको 3 मास ପାଇଁ bail जाएगी.
Yes. By chance to surrender.
You surrender at right time.
Yes, ma'am.
What was your conduct? Have you obtained this?
No, my conduct.
Get that. Let on. IN number 1684 of 2025 is an application for bail. Land and counsel for the petitioner submitted that the petitioner was granted interim bail for a period of 3 months as per order dated 13/5/2024, and after availing the same he surrendered at right time.
Yes.
State counsel takes some time to obtain instruction regarding the conduct of the petitioner while on interim bail and also the custody certificate. Put of this matter at one point.
And appearing for the informant.
The name of Mr. Parthasarathi Naik shall not be reflected in the cause list henceforth. You are Mr.
Rakesh Behra.
Mr. R. Behra, land counsel for the informant is present. Next are जोटा अच्छी connected matter.
Yes, ma'am. Correct. अधिका दिन.
हाँ.
अधिका दिन से same order है.
अच्छा. ସେଇ ଗୋଟେ ଅର୍ଡରରେ ଯାଇଥିଲେ ନା ଅଲଗା ଅଲଗା? ଏଇ ଯୋଉ ସେକେଣ୍ଡଟାରେ ମଧ୍ୟ ସେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଯାଇଥିଲେ ବଟ୍ ଦ୍ୟାଟ୍ ଡେଟ୍ ଇଜ୍ ଡିଫରେଣ୍ଟ। ଅର୍ଡରଟା ଦେଖିକି ଲେଖିଦେବେ କୋଉ ଡେଟ୍ରେ ଯାଇଥିଲେ ହେଲା। ବାକି ଆଉ ସବୁ ସମାନ ରହିବ। ପାର୍ଶ୍ୱ ସାରଥୀ ନାୟକଙ୍କ ନାଁ ଲେଖା ହବନି, ବାକି ଆର୍ ବେହେରା ପ୍ରେଜେଣ୍ଟ କରି ସବୁ ରହିବ। And these two matters should come together ହେଲା। Okay.
Item 31.
Mr. Malik.
The present appellant is the husband, my lord. Present appellant is the husband.
ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି?
ନାଇଁ, not press କରିଥିଲି।
ନଟ୍ ପ୍ରେସ୍ କରିଥିଲେ। ଅଫେନ୍ସ କ'ଣ?
498-304 be acquitted. Conviction is 302.
ଏଇ ଯୋଉ ସେବେଠୁ ରହିଲେଣି?
Inside custody, my lord, from the date of judgment 27/12/23, and before the judgment he was inside custody 2 years 7 months 5 days.
Total period କେତେ ହେଲା?
4 years 6 months 15 days.
Cause of death କ'ଣ?
As per the doctor evidence, my lord, PW 19.
Discussed in page number, paragraph number. Death is homicidal କହୁଛନ୍ତି ପରା? Paragraph number 19 ହଉଛି PW the doctor. Evidence has been discussed also. You also found through abrasion, hard bone fracture ଅଛି, larynx ସବୁ ଗୁଡା fracture ଅଛି, asphyxia by constricting force around the neck, consistent with strangulation. That is page number, internal page 9, running page 24. So ଆପଣଙ୍କର ସ୍ତ୍ରୀ ଆପଣଙ୍କ ପାଖରେ ଥିଲା
On the date of
homicidal death,
as per the defense, my lord, he was not present, my lord.
ଆଉ କିଏ ରହିଛି ଘରେ?
DW12 and believing by DW12, father-in-law and mother-in-law are acquitted.
ଆପଣଙ୍କର କିଏ ରହିଲା ଏମିତି କରିବା ପାଇଁ?
ଶାଶୁ ଶ୍ୱଶୁର
ଆପଣ ଯଦି ବାହାରକୁ ପଳେଇଲେ, ଆପଣ ବାପା ମା ତାକୁ କଲେ ବୋଲି ଆପଣଙ୍କର କହୁଛନ୍ତି?
acquitted.
Acquitted ହେଲା।
By believing
finding ଥିବ ଯେ ଆପଣ ଥିଲା ଏକୁଟିଆ। ଡେଡ୍ ବଡି କୋଉଠି ମିଳିଲା? ବେଡରୁମରେ? ବେଡରୁମରେ ମିଳିଲା।
ଓପନ୍
ଗଳା ଚିପା ହେଇକିନି ମରିଛି। ଆପଣ କହୁଛନ୍ତି ଯେ ମୁଁ ନଥିଲି ବୋଲି। Have you taken such a plea during
DW1, DW2,
question number 27.
That was rejected, that the trial court has disbelieved your
believing one part.
କଣ ଦେଖିବା କଣ ନେଇଛନ୍ତି plea ଆପଣ?
At the time of occurrence, you were to see the dando major with the friend.
Deceased was found hanging position in your house. What do you say? ତାର ପେଟ ଖରାପ ଥିଲା, ମେଡିକାଲରୁ ଔଷଧ ଆଣିଲି, ସେଦିନ ଗାଁରେ ନାଚ ହଉଥିଲା, ମୁଁ ନାଚ ଦେଖି ଯାଉଥିଲି, ଆସିଲା ବେଳକୁ ଦେଖିଲି ସେ ଝୁଲୁଛି। ଝୁଲା କେସ୍ ନୁହେଁ ନା? ଝୁଲା କେସ୍ ନୁହେଁ, ତାର ତଣ୍ଟି ଚିପା ହେଇକି ତାପରେ ତାକୁ ଝୁଲେଇ ଦେଇଛନ୍ତି, ଅନ୍ୟମାନେ ଦେଖିଲେ।
As per the honorable appellate decision, my lord, one person cannot, a able woman cannot be hanged by a person, as there is no one in the prosecution.
ଆପଣ ମରିଗଲା ପରେ strangulation ପରେ ତାକୁ ଟାଙ୍ଗି ଦେଇଛନ୍ତି ଆଉ କଣ?
Good fellow.
ଆପଣ the plea which you have taken that ତା ଦେହ ଖରାପ ଥିଲା, କଷ୍ଟ ନ ପାଇ suicide କଲା, that is contradicted by the PM doctor's evidence.
There is no mark of violation, my lord.
South of 50 corridor from Dasara for yes, next.
It's even out of the
Puja vacation, next.
Item 32.
No, yes, next. Interim bail କଣ ପାଇଁ ପକେଇଛନ୍ତି? ଆଣିଛନ୍ତି instruction କଣ ଆସିଲା?
Health condition is good and she is not under any treatment.
Not under treatment.
Not under any treatment.
IN number 1 is an application for interim bail on the ground of wife's treatment. The land council for the state was asked to obtain instruction on the interim application. Today, the land council for the state has produced the written instruction received from SI of Polsora police station, who stated that he visited CHC Polsora, discussed with Dr. Amrita Sahu, MOCSC, regarding the treatment of the Pushpa Naik. And the MO stated that the wife of the petitioner visited CSC for treatment of her long time so menstrual bleeding, and no such major health issue was observed in respect of the wife so.
Mother Srimati Pushpa Naik stated that her health condition is good and she is not under it.
The wife also stated that her health condition is good and she is not under any treatment.
She doesn't want that use.
Report is taken on record. The interim bail application stands rejected. Yes, next.
Item 33.
May I please? On behalf of Mr. Patel, I have submit finance. In this case, my lord, the report was added in the record, my lord, regarding one of the routine that my lord.
Custody certificate clean.
Yeah, record, my lord.
Custody and
11 years now.
that is on record.
There on record.
Record ଅଛି ବୋଲି ଲେଖା ହେଇଛି କୁଆଡେ ହବ? ଅଛି। କେତେ ବର୍ଷ ହେଲାଣି?
11 years, more than 11 years.
ହଁ।
20/4/2014.
May ମାସରେ
10
ଥିଲା
year
ଆପଣ।
11 months. As on 5/5, 10 year 11 months.
ମାସ ହେଇଗଲାଣି ସେ 11 ବର୍ଷ ହେଇଗଲା।
11 ବର୍ଷ।
ଆଉ ବାକି ଆଗରୁ କେତେ ଥର ରିଜେକ୍ଟ ହେଇଛି?
ଆଗରୁ first time ହେଇଛି।
ଫାର୍ଷ୍ଟ ଟାଇମ୍?
Reject ହଉଛି।
ସିଙ୍ଗଲ ମର୍ଡର?
My lord.
Single man, 7-8% are injured. Who are the witnesses here?
ଅଛି ଆଉ କିଛି
Injured witnesses.
କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ କିଛି ଅଛି? ଏଇଟା?
One accident.
କି ଅଫେନ୍ସ?
379, 506, 323,
କେବେକାର?
341.
କେବେକାର?
2013.
ସେଟା ବଢେଇ ଦିଅନ୍ତୁ ସେଟା। Are the learning counsel for the petitioner, learning counsel for the state? The learning counsel for the petitioner submits that the petitioner is in judicial custody for more than 11 years, which should be evident from the custody certificate obtained from Superintendent District Jail, Kendrapada, which is on record. It further submits that there is no chance of early hearing of the appeal. Therefore, the bail application may be favorably considered. Land counsel for the state has produced the written instruction received from ପାଇଛନ୍ତି ଦେଲେନି କି କଣ କହିଲେ ପରା ଗୋଟେ କଣ କେସ୍ ଅଛି?
So that is on record.
ହଁ
It is already on record.
ଅଛି ଏଇଟା?
Yes, along with the custody certificate, that is already on record.
ହଁ ହଁ ଠିକ ଅଛି ଯଦି ଫେରିଗଲି IAC all police station place this one so which indicates that the petitioner has got one criminal antecedent of the year 2013 in some magistrate travel offences.
Yes.
Stop. Case based on eyewitnesses account. Further submits that there are eyewitnesses.
1 to 8.
And there are injured eyewitnesses.
And some of the eyewitnesses are injured and they have reposed against the appellant who have committed murder of single deceased. Of the deceased. In view of such materials available on record, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody. Yeah, I'm keeping in view as a application. We are inclined to release the petitioner and maintain bail for a period of 3 months. While an interim bail, the condition would have also not indulged once again. Back to the IA for sterilization of fines, it will allow them. Which one?
Guji alias Pansal.
Guji.
104.
Yes, total
5 ବର୍ଷ 1 month.
4 year 2 months. 2025/4/2025. It's 4 year 2 months.
जाओ एका छुट्टी पर उठो एटा वैकेशन पर एटा पूजा वैकेशन पर inside custody file after that. After shooting for us. Okay.
Item 34.
Mr. Chan, first application. Conviction for life matter. ये deposition copy दे दीजिए ना. Paper book है. PW 11 is none other than the brother. And the evidence that when the meeting was going on, and the parent petitioner reached the meeting and challenged the authority as to why his money has not been. No, there are other witnesses for PW 11 I want to place matter. Because from his evidence is clear that there before the occurrence, before the assault was there was a quarrel, a free fight, and resulting this alleged assault on the spot. What is the name of the deceased? The deceased is
Charana Pradhan.
yes. Charana Pradhan.
Yes.
How many persons assaulted him? Only one.
Only one.
But you are the person. So the prosecution case, a meeting
By
was
means of a knife, he stabbed.
meeting was held for the purpose of discussion regarding that Dhodi Rua, the process of cultivation. And the meeting, the parent petitioner reached there after some time and asked the authority as to why my money has, which I have materialized, it has not been given to me. And by the process, each arose. And during that particular process, it is alleged that some persons surrounded the parent petitioners and also opposed him. And at that relevant time, the deceased, who was no way concerned matter, he intervened, and thereafter it is alleged that the parent petitioner, by means of a knife, gave two push on the chest and on the abdomen of the deceased valor. Then thereafter, Doctor is W.
20.
Yes.
PW 20.
And he was taken to the nearest hospital. The doctor was not there, for which he was referred to the DHH, wherein he was subsequently. Three stab blows you have given. Two.
The chest.
Tinta. Specific अछि. One hochi left side chest. Ek number. Two number hochi. Out injury, separate injury. Tinta separate injury hichi left side chest. Hala. Different sizes wrong. And it has penetrated. Just the glass of the evidence of PW 11. We have seen that, but it is not a case of single blow. No, I have not seen. So PW 11 parasitic. All your attempt was on the chest and the left side's chest. The heart is there, so you have assaulted, and that has penetrated to
lungs.
Lungs also. Para 16. How many years you are in custody? 2018 January. So, 7 years बाकी तारो क्रिमिनल ट्रैक रिकॉर्ड टानो एटा लेखन आफ्टर पूजा हॉलिडे है ना इन द मीन टाइम कस्टडी सर्टिफिकेट आनिबे है ना गुप्ती होताउची एंटीसीडेंट आनिबे और जेल कॉन्ट्रैक्ट तीनटा यस नेक्स्ट
Item 35.
On behalf of Naik Matter, Petitioner Appearance, this case matter, the petitioner released on bail, interim bail on 7/8/2024 matter.
Calendar call it fix somewhere.
Fixed that time matter, the corporate secretary call for matter, and also the regarding during course of interim bail conduct matter.
Conduct is good. And what about the custody certificate? କେତେ ବର୍ଷ ରହିଛି
11/9/20 ରହିଛି 4 year 8 months
11/9/2020
11/9/20
ଆଣିଛନ୍ତି custody certificate ଆଣନ୍ତୁ ସେଟା ନେଇ ଆସନ୍ତୁ next week ର ନବ ଲେଖ the learning council for the state has produced the report of the IAC Kabisudhyanagar police station which shows that the conduct of the petitioner during the interim period was good. The report is taken on record. However, he seeks some time till next week to obtain the custody certificate. Put of this matter on such and such. But yes.
Item 36.
Mr. Gonzo,
May prejudice. Here, my lord, appellant is a language. That was 3/2/2018, my lord. Of convicted 3.
Agul reject
No. The lawsuit has called for antecedent also. Custody
criminal antecedent ପାଇଁ ରଖା ହେଇଥିଲା ଆଉ custody certificate
ଅଛି ଆପଣଙ୍କ ପାଖେ?
flag ହଁ ଅଛି custody certificate ଅଛି 7 years 3 months. This is name is Leah Prakash.
Liu Praska.
Liu, Liu Praska. Nothing adverse action. Aguru bail reject ହେଇନି?
No.
କଣ ଆପଣ କଲେ?
Allegation, they are related relations, my lord, related to each other. On the occasion of my lord, PW3, my lord, it has completed as 30 years of marriage.
Eyewitness किए?
PW3. And 3 and 2 the occurrence at the
eyewitness किए पछे
PW3.
Only eyewitness.
And also PW3, PW8.
Why are you reluctant to tell the eye?
PW3, PW8. These are the 2 eyewitnesses.
Yes, my lord, and PW2 also. So far as
PW piecemeal କହିଲେ ଆପଣ ଭାବୁଛନ୍ତି suppress କରିଦେବେ ନା କଣ? ଯୋଉଟା ଆପଣ ପଚାରୁଛି eyewitness କହିବେ ଆପଣ
PW2, PW3 and 8.
PW2, PW3 and PW8. Who is the doctor?
Dr. PW7.
PW7.
PM doctor.
Yes, my lord.
You come to any eyewitness statement.
PW3, man.
PW3 upon press करेगा. Press कौन? Form से कोई. There was altercation between accused Liu Praska and what is the name of the deceased by the way?
Name is Brunda Kulesika.
Brunda Kulesika. There was during night myself so and so were taking rest in one house of Pandu. My husband was taking rest on a cot in that room. At about 1 a.m. during night, accused Liu Praska with the swan so marked as MO1 inflicted blow on the chest of Brunda, as a result of which Brunda died. Liu had inflicted blow to his own wife and to myself. Oh, there are injured eyewitnesses.
PW3 and wife.
Wife.
PW8.
And the doctor has noticed a stab wound on the chest.
Only
near sternum. So the prior to the this overtack which was committed by you, there was no sudden quarrel, nothing of that.
Altercation this
that subsided since long. That took place in the 10 o'clock in the morning, and you came prepared with the weapon in the night. And the
all were taken rest. All were invited for the marriage occasion.
No, it's not a case of sudden quarrel, and during that quarrel, you stabbed the deceased. It's a case where
on the morning.
Morning, ସକାଳେ ଗଣ୍ଡଗୋଳ ହେଇଛି.
I was seeing is a crossing. There is a disturbed state of mind, and PW8 says there's some problem. PW8 in his cross-examination has stated has used support from some mental instability, and that gathering was
mental instability.
Yes, ma'am. And the PW also 3 has stated, to my belief, Liu Praska was of disturbed mind.
ये तो तार सोई चला था रात्रि राशि
They say no matter weapon of that was not kept, that was kept in the all were invited. I am also cousin brother. All were invited for the marriage occasions, 30 years marriage. So in the morning there was a quarrel altercation between the deceased and the present appellant. And in the they have right allegation is that and no
so they are all related to each other.
Yes, my cousin matter. All are
Related to each other.
all are invited.
What was the motive?
Motive nothing, no, there is also no sudden ସକାଳେ ଯୋଉ ଗଣ୍ଡଗୋଳ ହେଇଛି ତାପରେ ରାତିରେ
What is the age of this appellant?
Appellant my 52 years. And custody single से कुछ रात्रि देखा जाए it is difficult to refer.
Out of this matter, I shall recommend the land council for the state has produced the report from the IIC Doraguda Station. It shows that there is no criminal antecedent in the petition. The same is taken on record. Put up this matter after ensuing to Jahal. Yes, ma'am.
Item 37.
Sulochana Patro. Next, Penandi.
Item 38.
Dr. Smriti Ranjan Rao.
Last petition, it will request out in the qualified report.
Regarding the status of the children now. Status of the children of the applicant.
Order detail 7/5/2025. Section the petitioner
You killed your wife after how many years of marriage?
15 to 16 years.
15 to 16 years.
There are 3 children, huh?
Yes, I think we'll take as well as their children. Even 15 has also one of the
It is ascertained that he has blessed with 3 children, out of which 2 daughters. Eldest daughter is married, is residing with her husband. Younger daughter is 12 years, studying in class 1. Only son, studying in class 10, residing in class 1.
You don't put in
15/6/2021. In 4 वर्ष
we don't put in one of the doctor. We don't put it the doctor. This case. We put it at
14.
14.
1/4.
1/4.
Is the
Second child of the deceased.
what is the doctor's evidence? How she died? Your wife.
PW.
Who is the doctor?
PW 4 years. Death was due to cardiocerebral injury and complication there. There are external injuries also.
Why he assaulted her to death? What is the motive behind the commission of?
PW 9 is the eyewitness.
9 is the eyewitness.
Sabitri has died since 2 years. On the date of occurrence during a quarrel, the accused hit his wife Sabitri by means of an iron rod on her head causing bleeding injury to her. I was taking water at that time and wanted to rescue Savitri, but seeing the rod in the hand of the accused, I came back running.
Single or doctor?
PW 4 years. Five external injuries.
Is a ଗୋଟେ blow ଭଳିଆ ଲାଗୁନି? Puncture laceration ଅଛି.
Yes.
Maybe that fall ହେଲା ପରେ କୋଉଠି ହଉଛି object ଗୋଟେ ଇଏ ହେଇଯାଇଥାଏ ମାନେ but eyewitness କହୁଛି ଗୋଟେ.
Yes, sir. PW 12 is also eyewitness. She has turned hostile.
No, it also not stated that the witness PW 9 was present at the time of operation.
Criminal antecedent?
That I have to check.
The period of custody or call
9 for 2025.
Criminal antecedent. The land counsel for the state, as per the order, previous order that they published, has produced the report from IIC, Markot Nagar Police Station, relating with a quarter fifth. Relating to the status of the 3 children of the appellant and the deceased. This is taken on record. He seeks some more time to obtain instruction regarding the criminal antecedent, if any, against the petitioner put of this matter after ensuing puja holidays. Yes. What is
Item 39.
Mr. Das, Anupam Das.
I'm appearing on behalf of Mr. The offenses under section 302, 304B, 498A and section 4 of Dowry Prevention Act. My lords,
Deposition copies is available with you?
Paper book.
Paper book.
No, Your Worship. Deposition copy.
Paper book अच्छी वन ठीक बता देना.
Deposition copies are there. There is no paper book. Deposition copies are there.
So it's a case of dowry death.
Yes, my lords.
And you are the husband.
I'm the husband, my lords. But it is
So how many years after marriage you killed your wife?
My lords, 2012 the marriage took place. 2014 a child was born, and the date of incident is on 30th December 2019.
What is the cause of death?
My lords, if my lord sees PW7, examination of PW7, the doctor, he mentions that mechanical asphyxia, but he also says that there is, in the PM report, he has not mentioned about the cause of death. PW7 is the my lords.
There are a number of injuries on the person of the deceased. That paragraph is paragraph number 10. Internal page is 16, drawing page 31. And there the evidence of the doctor PW7 has been discussed. And he has opined that there was also hematoma and cause of death was due to so mechanical obstruction around the neck.
My lords, if my lords.
So this rules out this.
And it's the hematoma bone, the thyroid bone was not.
Number of injuries are there. It's not a case of suicide. It's a case. The thyroid cartilage means that's a there is a struggle to save herself, and that is how these injuries are. Otherwise, if it would have been caused by hanging the oblique manner, the rope would have been there. So that is found missing. There is no ligature in
Should we time see PW10 for him?
PW10, who is he?
The doctor there.
Doctor.
Yes, sir.
7 also.
Doctor's evidence, internal phase 18. that is Professor FMT, MKCG, MCH, Barampur.
Yes, sir.
Injury mentioned in the postmortem which were antemortem in nature.
The number 2.
Out of subsequent query reports also
Possibility of death due to
homicidal
compression on
compression.
the neck cannot be ruled out.
Homicidal compression. The struggle achi.
Compression on neck.
Yes, my lord sees para 10 of PW7. PW7 is also a doctor. My lord sees para 10. It says, I did not find any thumb impression on the neck of the deceased.
That we can see in the final disclosure.
After eviction. Next.
My lord says,
Item 40.
After eviction.
Is your lordship? Yes.
Have obtained instruction.
On what ground?
For the first death anniversary of the appellant's wife.
IN number that is 2215.
IN number 2215.
2215.
कौन असला रिपोर्ट?
There would be a lot of problems.
Last year he had been released
But
to
previously,
attend the
But
obsequies.
is there no?
You are a political figure, so therefore they apprehend.
My lords, last year I was released for the death obsequies of the wife, my lords. Now, my lords, for the first anniversary, a 75 plus years old man, my lords, what will he do, my lords?
No, he will not do. The police apprehending that the other side may have caused some harm to the present.
Absolutely no apprehension, my lords. This is only because of the change of government now this has come.
24 ଯାଇଥିଲା କୁଆଡେ attend କରିବାକୁ funeral obsequies ସେତେବେଳେ ତ କିଛି ଗଣ୍ଡଗୋଳ ହେଇନଥିଲା adverse report IN number 2215 of 2025. This is an application for interim bail on the ground of attending the first death anniversary of the wife, of his wife. The London Council for the state has obtained written instruction on the interim application through Deputy Superintendent in charge, Petitioner, which shows that the petitioner was earlier released on interim bail by order dated 24/9/2024 for attending the funeral obsequies of his wife and surrendered on expiry of the said period, and there was no adverse report received regarding misuse of liberty either during trial bail or interim bail. It is further mentioned that considering the advanced age of the petitioner and his deteriorating health condition in custody, the plea appears to be bona fide. However, it is stated that the petitioner is a known opposition political figure, and therefore there is likelihood of law and order disturbance during his temporary release in view of the present political scenario. Stop. The report is taken on record. Third, Mr. Devasis Panda and Ms. Mehta and counsel, IC Mehta and counsel for the petitioner, and Mr. Nayak and an additional government advocate, after considering the averments taken in the interim application, the document annexed to the interim application and the report furnished by the Land Council for the state, we are inclined to release the petitioner on interim bail for a period of 1 week. The interim application is disposed of. Matter be listed on such and such date. The Land Council for the appellant shall produce the surrender certificate.
A small prayer, my lords.
During the interim bail period, the petitioner shall not indulge in any criminal activities.
Lords, a small prayer.
Yes, yes.
Can the order be uploaded and the trial court act on the uploaded copy?
Yes, yes. You can also get the order today itself. There.
My lords, obliged.
My appearance may be noted, my for information.
Mr. Malik or Rakesh Kumar Malik, the land counsel for the Interim is playing, you know. बाकी ये जो उड़ा काशी वो surrender कर दिया उठा फिर consider होगा, है ना. Rest of the matter of the बुधवार दिन, है ना.